This detailed cost assessment hearing is in the matter of case number CFI 046-2021 before Registrar Ayesha BinKalban. The detailed cost assessment hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the registrar's instructions. The claimant is represented by Baker Tilly Law Corporation for legal consultancy. Lead counsel is Shaheen Pulikal Vito. The defendant is represented by El Tamimi and Company. Lead counsel is Carl Anderson. Thank you, Madam Registrar.
Thank you very much. Mr. Anderson, would you like to make any submissions or to start off, please?
Yes, good morning, Registrar. As you know, I appear on behalf of Mashreq Bank PSC, which was the defendant in the main proceedings and the party which initiated these detailed assessment proceedings. And Mr. Shaheen appears on behalf of Ms. Khoury, who was the claimant in the main proceedings and the respondent to the detailed assessment.
Sorry, Mr. Anderson, sorry to interrupt. We can't see you. I don't know if that's intentional.
No, it's not. I'm sorry, Registrar. I've tried turning my camera off and on.
Okay.
Does that work?
Yes, that works.
Okay.
All right.
Okay. I apologize for that. As long as you can see and hear me now. Registrar, but before I get into the detailed assessment, I should say that obviously we received an email at 4:37 p.m. yesterday from Ms. Khoury's solicitors, which was copied to the registry, which I assume the registry has seen, which attached an application for a stay of these proceedings. And then a further email was received by us at about 7 p.m. also requesting that this hearing be adjourned. Now, we object to both of those applications, but in terms of our response to them, I don't know whether your preference would be to hear my submissions on those first or for Mr. Shaheen to make those applications. I'm very much in your hands.
Yes, I agree that would probably be the best way forward. Would you like to go ahead, Mr. Shaheen?
Yes, madam. Thank you very much. Good morning to all. See, there was a case filed by the same claimant before the Dubai Mainland Court. At that time, she did not have access to any of the documents on which the other side was relying on. Afterwards, when an expert was appointed, documents were presented. It was found that the proper jurisdiction clause stating that it is the DIFC. So in order to be on the safer side and to follow the proper jurisdiction, she applied before the DIFC court. It's a coincidence. She had to procure an expert report from one of the big four, spend some time in preparing the case to be presented to the DIFC court. On the same date when the DIFC court application was made, the lawsuit was submitted before the court of first instance. The judgment was delivered by the Dubai court. It's just a coincidence, not that somebody waited for the judgment. It's not possible. You can imagine the preparations, everything required for that. And first, she got a default judgment in her favor, which was set aside. Then there was a lawsuit trial. The case was decided against the claimant, against my client. In the meantime, in April 2021, we approached the DIFC court. That's 28 April 2021 to be precise. And in June, we had submitted an application before the JJC, Joint Judicial Committee at that time. And we asked the Joint Judicial Committee to decide on the jurisdiction. So as per the law number 16 of 2019, Article 5, I'm sure, madam, you are well aware, all proceedings shall be stayed. It's a mandate.
Sorry. Do you mean the law number 19 of 2016?
Yes, your lordship. Yes, I'm sorry. I think I messed with the numbers 6 and 9. Sorry. Thank you for clarifying that. Law number 19 of 2016, Article 5 very clearly state that shall be stayed. It's a mandatory obligation. It doesn't require an application of stay. The moment the court is informed, the court has to stay all proceedings, whether it's a lawsuit, cost assessment, execution, whatever the case. So we presented that application of JJC to both DIFC court and also to the Dubai Mainland Court. Dubai Mainland Court at that time was in appeal. Immediately they stayed all further proceedings and they stopped. Until now, they have not started anything after that. Unfortunately, DIFC court did not follow the law, Article 5 of law number 19 of 2016, and decided to proceed with the case. We did not stand in the way. We completely cooperated with the court. We participated in all the hearings. And then the judgment was issued against my client by the court of first instance. We preferred an appeal in May 2022. The appeal was also decided against us. Unfortunately, I can still criticize the judgment, not the judges. Okay, I'm not convinced with the interpretation, and I'm not convinced with the judgment when there is a clear jurisdiction clause that is stating otherwise.
Please move on. Yes, please move on, Mr.
We're not
Shaheen.
going into the details. I agree with you, madam. And we did not sleep on the application presented to the JJC. We would have submitted at least 6 or 7 reminders, 7 further requests to please expedite the process, come up with a proper judgment by the JJC. Under the law number 19 of 2016, it is up to the JJC to decide the jurisdiction. The courts below, I mean the DIFC court and the mainland court, are expected to stay all proceedings, not continue even 1 inch after. That is exactly where Honorable DIFC court unfortunately went wrong in proceeding with the case, which is vitiated by violation of law, which is irregular, and nothing can come proper from an irregular proceedings. So once JJC takes a decision, okay, on which court has jurisdiction, whether it's DIFC court or is the mainland court. Now we are continuing with the mainland court. Suppose the stay is vacated by the, suppose mainland court also followed the same course, and in the cassation or the appeal court, they decide that it is not us, it is the DIFC court who has to exercise jurisdiction on this. Where shall I go? What is my situation? DIFC court is saying no jurisdiction, mainland court is saying no jurisdiction. Suppose I'm taking a hypothetical situation, which is very much probable. Because of the contentions I have taken before the DIFC court, I'll be taking the same contentions before the mainland court also. So that is exactly why the legislation decided that is neither for the mainland court nor for the DIFC court to take any decision in this regard. It is the prerogative right, exclusive right of the JJC to decide which court has jurisdiction. And that decision is pending right from March 2022 until August 2023, and then on October 2023, I have submitted applications after applications before the JJC to speed up the matter. Now again, I'll have to approach the JJC, telling them that all these proceedings, what happened before the DIFC courts, are irregular and invalid because it's violating the provision of law. A mandatory provision of law is being overlooked, and these judgments cannot stand. And then it's up to JJC to decide. And if JJC decides, in my opinion, properly deciding that it is DIFC court which has to exercise jurisdiction, because jurisdiction clause is clearly referring to DIFC court and no other courts in that jurisdiction. If that happens, what happens to all these proceedings, what we have done in the DIFC court? What happens to the detailed assessment of cost, what is happening now? So nothing will stand. So we are in a futile exercise. We are going a long way. And who am I representing, madam? I'm representing an innocent lady who invested his lifetime savings with the bank, $6 million, including the inherited money. She did not do any other mistake. And now she is going to be punished, being slapped with costs also. This is where I'm coming strongly against any further proceedings, requesting the Honorable Registrar to please stay this proceedings until the JJC decides. I'm not telling to dismiss the application or anything. Stay it, hold it. What is the hurry? Let the appropriate forum decide which court has jurisdiction properly, and then we
I
proceed.
think I've heard enough, Mr. Shaheen. I think I've heard enough. I get the gist. I get the gist of your application. Thank you very much.
One more point, madam. One more
Please
point.
briefly, because we have an assessment to get to. Yes.
Just one more point regarding the stay. If we look at the law which applies to us, is the DIFC law. This is Part 40, procedure for detailed assessment of cost. Part 40, time when detailed assessment may be carried out is 40.1. When can we do a detailed assessment? 40.1 says, madam, the general rule is that the costs of any proceedings or any part of the proceedings are not to be assessed by the detailed procedure until the conclusion of the proceeding. In my opinion, the proper way, the proceedings are not concluded because it's still pending before the JJC. JJC can decide that it is DIFC. There is still the option left before the JJC. It is there. So our application is pending. Until such time that application is properly decided by the JJC, we have to hold on to this proceeding. We cannot take any decision. We should not proceed further with that irregular proceeding. That's my humble submission.
Thank you very much. Mr. Anderson, would you like to respond?
Registrar, yes, I can be quite brief with this, I think. So just to put this application in context, this referral to the JJC was made in June 2021, so 4 years ago. And I think Ms. Khoury admits that she didn't make any application for the DIFC proceedings to be stayed at any stage before they were dismissed by the Court of Appeal. And indeed, these detailed assessment proceedings were commenced on 25th of January, and Ms. Khoury has filed a 25-page points of dispute and only filed this application for a stay yesterday afternoon. So in that context, Registrar, we say this application is a clear abuse of process, but also, and more importantly, it's wholly without merit and is wrong as a matter of law. And there are two short points that I can take which deal with it completely. The first is this, that there can't be any sort of jurisdictional conflict between the DIFC and the onshore courts in this case, because the DIFC proceedings no longer exist. The claim form has been set aside. There are no DIFC proceedings. That's the whole basis of the orders which are now the subject to the detailed assessment. What Justice Glennie did was he set aside service of the claim form and declared that the DIFC did not have jurisdiction, and that ruling was upheld on appeal. So in other words, there is no claim on foot at the DIFC, so there can't possibly be a conflict of jurisdiction between proceedings in the DIFC and proceedings in the onshore courts. And at that point, we also say is determinative of this argument in relation to RDC 40.1, that the proceedings plainly have concluded because the Court of Appeal has ruled that there was no valid service of the claim form. So that's the first point. The second point, Registrar, is what follows from the Court of Appeal's judgment in this matter. And if you have a copy of the hearing bundle, could I just ask you briefly to turn up page 153, which is paragraph 72 of the Court of Appeal's judgment.
$153, Mr. Anderson.
That's right, Registrar, yes. It should be page 21 of the Court of Appeal's judgment.
I am there. Mm-hmm.
And it's paragraph 72. And if you look about 2/3 of the way down, the sentence that begins, "It is further unnecessary," what the Court of Appeal say there is, "It is further unnecessary for us to express any view on the reference to the JJC, whose role it would be to determine any issue of jurisdiction between the courts of the DIFC and those of onshore Dubai. No application was advanced to us by Ms. Khoury seeking its stay because of the reference to the JJC. And in any event, as is indisputable, if we dismiss the appeal, there will be no conflicts between this court and the courts of onshore Dubai." Well, that is exactly what the Court of Appeal did. They dismissed the appeal. So there are no DIFC proceedings on foot. And therefore, we say the Court of Appeal has already given a very clear answer to this. It's indisputable that there is no conflict between the DIFC and the onshore proceedings, and that there therefore can't be any basis for a stay as a result of the reference to the JJC. So we do say that those 2 points are wholly determinative application of this application. But in any event, we've as of last night, we added in the DIFC authorities to the bundle, which show that it's clear as a matter of law, since the DIFC Court of Appeal's decision in Lakan and Lamia, that a reference to the JJC no longer operates as an automatic stay. And what needs to be shown is that there is a conflict of jurisdiction. And I can just show you that if it would help, Registrar, at page 510 of the bundle. It's paragraph 31 of the Court of Appeal's decision in Lakan and Lamia.
Mm-hmm.
And what the Court of Appeal says at paragraph 31 is what triggers a stay is the existence of a conflict of jurisdiction in one of the forms in the chapeau to Article 4, and an application to the JJC to determine the competent court or the judgment to be enforced. Mere application to the JJC does not trigger a stay, and the court must be satisfied that there is a conflict of jurisdiction. And in terms of working out whether there is a conflict of jurisdiction, the Court of First Instance, a few months after this decision, handed down judgment in Emirates, MBD Bank and KBBO, which is at page 499, Registrar. If I could just very briefly ask you to look at paragraph 59 of that judgment. What the Court of First Instance said there is that it is clear that the decree only operates where there is a dispute or conflict as to jurisdiction between the Dubai courts and the DIFC courts, because both courts have claimed or both courts have disclaimed jurisdiction in relation to a particular dispute. And in that case, because the onshore courts had expressly disclaimed jurisdiction, there was no conflict. So in other words, under the wording of the article of the decree, there are only, the stay only operates if one of three things happens. Either both the onshore and the DIFC courts accept jurisdiction, they both decline jurisdiction, or both courts issue conflicting decisions. And that is, none of those conditions are satisfied here, because the DIFC courts have given a ruling saying that they don't have jurisdiction, whereas the onshore courts have taken jurisdiction. So we say you don't need to decide at this point whether under the old decree or the new decree, because they're of the point I made earlier that there are no longer any DIFC proceedings. But even if you did, it's clear as a matter of DIFC law that there's no basis for a stay because there is no conflict of jurisdiction. The DIFC having rejected jurisdiction and the onshore courts having taken jurisdiction. So Registrar, unless I can assist any further on this question, those are the submissions I wanted to make on that.
Thank you very much, Mr. Anderson. I am inclined to dismiss the application on the basis that there are no issues of conflict apparent at this stage in proceedings. We will be commencing with the assessment of costs. Mr. Shaheen, I don't think I've seen a skeleton argument from your end.
See, are we going into the detailed assessment of costs?
Yes, we are. Yes, we are.
Is it not for the other side to start then? They have submitted the application for detailed
I
assessment.
asked you a question. I asked whether or not you have filed a skeleton argument because I have not seen one.
No, it was, we have been asked whether we are submitting skeleton arguments, and we mentioned we don't intend to. And
Okay.
then they have submitted skeleton argument, but I don't have a copy of it until now. I've
Mr.
not received a
Anderson,
copy.
have you served the skeleton argument on the other side?
I'm sure we have, Registrar. Let me just take some quick instructions on that. But I'm sure we did.
I've not seen one. I've been inquiring with my colleagues. I have not seen one.
I'm just taking some instructions.
Mhm.
Oh, I think we might not have served the skeleton actually.
Okay.
I think it was
See,
only
madam,
sent to the registry.
The reason we stated that we don't intend to submit skeleton arguments is on the understanding or assumption, maybe a wrong assumption, that the other side is also not submitting. So they were asking us, but then to our surprise, they have submitted. I have not seen
I
it.
think there was a clear email from the registry asking for the provision of any submissions by an
Yes.
expected date. So just because the other side has not submitted something does not mean that you are not supposed to submit one. If you have a hearing, then it is most likely that you will be required to file a skeleton argument to support your points in dispute.
I'm referring to the email exchanges between the parties' counsels. So that was the wrong assumption, but that was the assumption on the basis of which we said we are not submitting, so you're also not submitting. This is what my understanding was. But if they have submitted a skeleton argument, I'm requesting for time to review it and respond to that.
You can review it during the course of the hearing, Mr. Shaheen. It doesn't seem to be anything other than what's in the points and the notice of commencement and the bill of costs. There's not much arguments that you would need to respond to. So you can respond to them. You can respond to them in the course of the hearing. Please do not interrupt me. You can respond to them in the course of the hearing, and then you can have the ability to file submissions in response, written submissions in response. But there's not much from what I can see from the skeleton. There doesn't appear to be any requirement for you to submit skeleton argument.
I reiterate my request with all due respect. I must be given time to review it and submit my skeleton arguments.
Thank you very much. You will be given the opportunity to make submissions during the course of the assessment. So anything that you need to say, you can say during the course of the assessment. And I will be providing you with a short opportunity to file written submissions in support of anything that you do not intend to say. But as far as I'm aware, this is a very straightforward cost assessment. There's not much that can be said in regards to a skeleton argument. All right, Mr. Anderson, if you would like to go ahead.
I'm grateful, Registrar. So you would have seen that this assessment arises out of 5 orders. 2 were orders for costs in the case and 3 were orders for costs in favour of my client. And I don't intend to take you to them in the bundle, but just to recap what they were. The first was the order made on the 5th of August 2021 by Justice Almeri, granting my client's application to set aside default judgment, where she made an order for costs in the case. The second order was then the order of Justice Glennie of 29th of March 2022, where he granted my client's application to set aside service of the claim form and declaring the DIFC courts didn't have jurisdiction. And he therefore at that stage made an order that Ms. Khoury should pay the bank's costs of the claim on the standard basis. So that's the first order that gives rise to a costs obligation. The third order was then a month later on the 29th of April 2022. That was Justice Glennie's order refusing Ms. Khoury permission to appeal his order. And again, he made an order that Ms. Khoury pay the bank's costs of applying for permission to appeal. That corresponds with part 9 of our bill of costs registrar, and the previous two orders correspond with parts 1 to 8. And then the 4th and 5th orders were the Court of Appeals orders, 7th of July 22 and 28th of November 22. The first one, the Chief Justice made an order granting Ms. Khoury permission to appeal and made an order for costs in the appeal. And then the second order, the Court of Appeal obviously dismissed the appeal and ordered Ms. Khoury to pay the costs on the standard basis. So those are the orders which give rise to this assessment. And you'll have seen from our notice now, Bill, that the total cost that we seek are 633,977 dirham and 51 fils, which is roughly about 3% of the value of the claim overall. So those are the total costs that we're seeking. But before going through the bill, there were just a couple of very short preliminary points I wanted to make, hopefully to speed up the process of going through it item by item. First, you would have seen that there was a suggestion at points of dispute that my client's costs should be disallowed entirely because these assessment proceedings weren't initiated in time. But what RDC 40.13 provides is that the court isn't able to impose any sanction in respect of the delay in initiating detailed assessment proceedings, other than to disallow interest. And I'll come on to the question of interest because we are happy to have a sort of shorter period of interest as a result of that delay in initiating these proceedings. Second preliminary point I wanted to make briefly was on hourly rates. So we obviously now have the Registrar's Direction 1 of 2023 on indicative hourly legal rates. If you could please just turn up bill of costs at page 165.
Sorry, Mr. Anderson, there seems to be some sort of cutoff in your voice. Did you just give me a bundle reference?
I did, Registrar. It was page 160.
160.
Can you hear me okay now?
Yes, yes.
It should be the page that sets out the hourly rates. And you can see there that all of the rates are well below the rates included in the Registrar's Direction. So I just wanted to make that point clear and ask you to bear that in mind throughout the assessment, that essentially my solicitors have conducted this case on hourly rates which are below the indicative guideline rates. The third overall point or preliminary point to Registrar is just a point about reasonableness and proportionality. And as I've already said, the overall figure we're seeking is only 3% of the value of the claim. I've set out in my skeleton what we say about each of the factors under RDC 38.23. So I won't repeat them, save that in respect to the conduct of the parties, we do say that the attempt to apply for a stay at the last minute by Ms. Khoury is another example of what we say is a long line of improper behaviour in this litigation. So we ask that to be borne in mind when the court is considering the conduct of the parties. And fourth, you'll have seen at paragraph 21 of my skeleton that we've responded to a number of the general points raised in the points of dispute. And I don't intend to run through them, but there is one point that I wanted to address, which I think might be able to save quite a lot of time when we go through the individual items. And that is this point about the bill of costs, including multiple claims for or in chunks of 185 dirham in respect of emails out. And the criticism made against us that we haven't provided details of the minutes worked in respect of those emails. And in my submission, it seems that there might be some confusion in relation to this, because it seems that Ms. Khoury is under the impression that the bank is claiming 185 dirham every time it presses the send button on an email. But that isn't right. And as we've explained in the points of reply, what we have done is, in the absence of express RDC rules on this, we follow the English civil procedure approach, which is that where a party engages in routine correspondence, the CPR says that you charge out by 6-minute increments, which is exactly what we've done. The 185 is 1/10 of Mr. Brooks' hourly rate. And there isn't any general requirement that the claiming party needs to explain what the routine correspondence relates to, because it is routine, and the solicitors have obviously signed the bill of costs confirming that it has been incurred. But for completeness, as we go through those, if you do have any questions about the routine correspondence, I can answer them. But in essence, we say that where there is a criticism in the points of dispute, that an email has been sent under the email out phraseology, it's just routine correspondence. There isn't any basis to dispute it in the points of dispute. So, Registrar, that was all I was going to say in terms of preliminary points before we now go through the bill item by item. And I wonder whether would it help perhaps to have, if you can, the bill open as well as the points of reply at the same time. And the reason I suggest having the points of reply open is that we've included a table that includes both the points of dispute and our reply to the individual items. So you can basically see all of the parties' arguments in one go.
Just bear with me. I think I can manage to pull that up. Okay.
I'm grateful, Richard.
Right.
So
Ready.
I think yes. So I think we now need to go through item by item. And unfortunately, as you would have seen, Ms. Khoury has challenged almost every single item in our bill of costs. Is the best way for us to do this, Registrar, for Mr. Shaheen to take you through his objection and me to take you through the reply in relation to each item, or would you prefer to hear from me first and then Mr. Shaheen?
No, I would like Mr. Shaheen to respond, and then I'll hear from you, Mr. Anderson. I think that would be more effective.
Okay, I'm grateful. So if we then start with item 2 and the reference in the points of reply. So I'll be going through the points of reply from page 2 to 8 of the bundle onwards. This is to the first item, item 2, cost claimed in respect of a 36 minutes letter out. The Ms. Khoury's position is that it's a one-page letter, doesn't have any specific details, but our position is that this was a detailed letter in the sense that it had to set out by reference to the rules of the court why service was invalid, and obviously there was some research that had to be done in relation to pointing that out. And we said that in that context, 36 minutes for that letter is plainly a reasonable amount of time, especially given that it was ultimately correct as a matter of law, that letter, and it did result in service being set aside. And we should also plainly be entitled to the 6 minutes for drafting the covering email to send that letter as well.
Mr. Shaheen, would you like to respond?
First of all, let me make it very clear that my continued participation in the detailed assessment of costs, as it was the case before the lower court and the appeal court, it's all without prejudice to our definite stand that we are going in violation of Article 5 of the applicable laws. First one, the law number 19 of 2016, and then the law number 29 of 2024, Article 7. So I'm reserving all my rights, but I wish to cooperate with the Honorable Registrar, and I'll continue. See, the costs being claimed by the other side is highly exorbitant. First of all, we should understand that we never went into the merits of the case. It was all the decision about one paragraph, whether the court has jurisdiction or not. That's the main thing that has been decided. We never had an opportunity to even talk about the merits of the case, just to decide on the question of jurisdiction. The cost claimed is in the range of 700,000 dirhams. So it's highly exorbitant. I have given my point-by-point comments on the cost submission. I would invite Honorable Registrar to please go through it. And in the interest of time, I don't want to repeat everything what I have stated in the written submission there. And since there is a skeleton argument presented by the other side, I may please be given a copy of it and sufficient time to study it and respond to that. And my humble submission, without prejudice again, is to be most considerate, because it's an innocent lady. Only mistake she did is invested her lifetime savings with a mighty bank, trusting them, entirely wiped out $6 million. This is all she has done. She has not caused any losses to the bank. On the other hand, the bank has caused lifetime savings loss to the claimant here. So the Honorable Court may be considered, even in a murder trial, suppose somebody is sentenced to death sentence also, there is an application for mercy. So at least show some mercy to the innocent lady who invested money with the bank. And this cost application, either it should be dismissed or it should be stayed at least, or if not, at least bring it to the bare minimum. We have even offered 150,000 dirhams, which is the maximum in the current position the claimant can afford. And that's also without prejudice in 2 installments we had suggested. So I request the Honorable Court to please consider my applications and decide accordingly.
Mr. Shaheen, there was never any direction that you will be providing a skeleton argument in response to the defendant's skeleton argument. There was never a direction to that effect. Your skeleton argument was directed to be provided by a specific date. You did not do that. So please do not interrupt me. The reason why I'm allowing you time to review, to find submissions in response, is because you have not seen the defendant's skeleton argument and have not, in my view, prepared to the extent that you would have liked to prepare. In any event, all of the points put in Mr. Anderson's skeleton argument are the points that were put in the commencement and the replies to the points of dispute. There is nothing new there. And I've already made my decision on the application for a stay. We are not going to be staying these proceedings. There are no proceedings as far as I'm concerned. The Court of Appeal has declined to take jurisdiction on this claim. I'm not going to rehash this matter over and over again. We are going to be proceeding with the assessment. The way we do this is we go line by line. If you would like to participate, you are more than welcome to. But if you don't want to participate, that's absolutely fine. We're still going to go line by line. Do you have any specific submissions to make on the point raised in regards to item number 2 of the bill of costs?
I most humbly submit the Honorable Registrar has completely misunderstood my submission. I never said I don't want to participate. I said I will participate, I will fully cooperate, but that's without prejudice. That's my right to say.
All right. So that effect, do you have any submissions, Mr. Shaheen, to make in regards to line item number 2?
I have not seen the skeleton argument on which Honorable Registrar is expecting.
Mr. Shaheen, the submissions are being made in regards to the bill of costs, not the skeleton argument. The bill of costs to which you have already responded, or your client has already responded, with points of dispute. And you would have seen the other side's reply to the points of dispute. That is all that we're discussing right now. We are not discussing a skeleton argument. We are discussing the bill of costs, which you have seen and have responded to.
I've already given my points on point by point. I have given the submission before the Honorable Registrar, and I insist on it. And I'm only requesting the Honorable Registrar to be considerate. That's what my submission was.
All right. All right. So if you have no submissions to make in response to what Mr. Anderson has said, I will allow full amount of costs in regards to line item number 2.
I'm grateful, Registrar. If you then go over the page and the points of reply, there is a further, there's a one email out in relation to item 2 as well, but that falls under the routine correspondence point, that 185 on page 229 of the bundle. So I was just going to ask that be allowed in full as well.
Yes, that's allowed.
I'm grateful. Then on to item 3, you'll see these are various telephone calls, emails out that we have claimed for. Ms. Khoury's point is that there appear to be entries that are redundant. The short answer to this is that although the descriptions relate to the same subject matter in the bill of costs, the short answer is that you can obviously send more than one email and have more than one call about the same thing. And all of these emails and telephone calls relate to something that was obviously highly important, because Ms. Khoury had wrongfully obtained a default judgment of nearly $6 million against my client. So my client plainly had to make sure that it had got everything right in terms of investigating the position and discussing it internally before then making the application to set aside the judgment in default. And that's the point that's made in the points of reply, that the application set aside was obviously highly important. And in that context, the total costs going to respect of item 3, which is just under 7,000 dirham, we say can't possibly be unreasonable or disproportionate in that context, because it was an application to set aside a $6 million default judgment.
Mr. Anderson, in the bill of costs, it says 1 long telephone call.
Yes.
How long are we talking about? That it warrants 820 dirhams.
I'm just looking at the. I'm just looking at the bill of costs itself, Registrar. The long telephone call is actually, if you look at page 11 of the bill of costs, is actually 12 minutes. I'm not sure, actually, looking at item 3 in the bill of costs, I'm not sure where that figure of 820 actually comes from. Oh, sorry, no, that's the point before. It's conference with the defendant to discuss strategy in the application to set aside judgment, 24 minutes. So it's a 24-minute conference with the client to discuss the strategy moving forward, and whether or not to bring the application to set aside the default judgment. So it's obviously an important phone call because it's with the client in order to discuss what is going to happen moving forward in relation to the default judgment.
So, and there is another telephone call conducted by Mr. Brooks.
Yes, then underneath that, exactly, yes, then there's another one providing advice on application to set aside 12 minutes.
Mr. Shaheen, would you like to respond to that point?
I would like to respond generally, Adam. That's one invitation to Article 38.18, the basis for assessment. Here, the cost is to be assessed on standard basis. This is stated in the judgment itself. So what does standard basis mean? The article says, were the amount of cost to be assessed on the standard basis, the court will only allow costs which are proportionate to the matters in issue. What is the matter in issue before the Honorable Court? Only the jurisdiction. No decision is taken on the $6 million. There was not a consideration at all. It's only on the jurisdiction. And for that jurisdiction, whatever cost on whatever ground they have claimed is highly exorbitant. It's just the jurisdictional matter. Merits have not been discussed before this Honorable Court in any stage. So that's my submission generally. Point by point, I've already given my comments and I stick to that. Thank you, Madam.
Mr. Anderson, do you have anything you would like to say in response?
I don't think so, Richard. I mean, you have my submissions on those specific aspects of reasonableness and proportionality in relation to this claim. And obviously, the big point is that these are only 3% of the value of the claim, and it was a very complex question about setting aside the claim form jurisdiction. The fact that the matter didn't go into the merits, we say, is irrelevant, because we ultimately succeeded in having the claim form set aside anyway. But no, I don't. You have my submissions on the general point, so I just intend to take you through the item by item justifications. Noting it at the same time, obviously the only reason here is because Ms. Khoury applied for and obtained permission to appeal to the Court of Appeal. So essentially, my client has been dragged all through the Court of First Instance and the Court of Appeal, forced to incur these costs along the way, and now faces a challenge to every single item in the bill, basically, that it seeks to claim. So yeah, we do ask you to bear that in mind as a general point as well.
All right. So, Mr. Anderson, I'm going to rely on you for the arithmetics when drawing up the order. I would like for a 15% deduction to be made in regards to line item number 3.
To the whole item, Registrar.
The whole item.
Yes. So what we'll do is once we finish the assessment, obviously we will do the maths, and when we draft the order, we will obviously include the final figure as well, and we can do that in relation to any interest as well.
Mm-hmm.
I'm grateful. Okay, so 50% deduction in relation to 3. In relation to 4, then again, this is just a routine correspondence, so we just ask you to allow that 185 dirham.
Anything with correspondence, I'm going to allow. So if there's any specific line items on that, you don't need to take me to them.
Okay, fine. I'll just sort of tick them as I go then, just so that I have them. Item 5, I think is the same. It's just correspondence, 370 and 185. Item 6 is then the next substantial one, Registrar, which is page 231 of the bundle in the reply. This relates to the drafting of the witness statements for the application to set aside the default judgment, and Ms. Khoury's position being that the 20 hours that we've spent drafting the witness statements is exorbitant given the complexity of the submissions made. Well, in response to that, Registrar, we say that these costs are obviously reasonable and proportionate for an application to set aside a $6 million default judgment. The witness statements themselves had to go through quite a lot of detail with regards to what was happening in the onshore proceedings, because you'll have seen from the background to my skeleton that essentially an almost identical claim was then brought in the DIFC as the one that had been initiated by Ms. Khoury onshore. And in particular, what had happened in the witness statements in relation to our set-aside application was that a lot of serious allegations had been made against my clients in relation to sort of bad faith and things like that. And they did require a response so that the registry had the full picture. The only other point that's made by Ms. Khoury in relation to this item, Registrar, is that Mr. Brooks' witness statement was in part drafted by Mr. Dylan Malone. But of course, there's no issue with a legal representative helping to draft a witness statement that's ultimately given by another legal representative. And in any event, both Mr. Dylan Malone and Mr. Brooks were on the same hourly rate anyway. So we say there's no point really to be taken there. So we do say that those total costs are reasonable and proportionate, given the importance of applying to set aside what was held to be a wrongly obtained default judgment for $6 million.
Mr. Shaheen, do you have anything in response with regards to line item number 6?
Yes. As I already mentioned, madam, I'm not interested in going item by item altogether. It's exorbitant. I've already given my comments on each item under my submission. And if since a skeleton argument, which I have not seen, I have reserved my right to respond to that, I'll respond to it.
All right. Mr. Anderson, could we perhaps cut down the hours of Mr. Dylan Malone by half?
Yes, Registrar. So 2 hours and 6 minutes rather than 4 hours.
2 hours and 8 minutes, I believe.
Sorry, yes, 2 hours and 8 minutes rather than 2 hours and 6. Yeah. That is why I'm an advocate and not an accountant. I'm grateful.
All right, and just before we move on, Ms. Jaballa's rate here, am I correct in assuming that Ms. Jaballa did not participate in the drafting and this was more of reviewing?
We can see that in the schedule of work done, I think, Registrar, which is, just get the page up for you. Page 192 of the bundle is the schedule of work done for this. And the Ms. Jaballa's time claim, the first one is the 4th of July. Considering present position and steps to be taken in light of judgment, attending internal strategy meeting regarding application to set aside judgment, agreeing next steps. That's 2 hours. And then a bit further down, 6th of July, perusing draft documents and updating witness statement and draft order. So as you say, Registrar, sort of reviewing the document after it's been drafted. So it wasn't a situation where we're spending partner time drafting it from scratch. Obviously, it's the partner is reviewing the sort of draft version in order to make sure that it's good to go before it's filed. So I think that those are the sort of big chunks of Ms. Jaballa's time. There's one further out on the next page, which is reading and considering reply submissions and considering reply evidence, and then attending internal strategy meetings. So it is sort of Ms. Jaballa's time is high level involvement rather than getting into the weeds of drafting.
Can we also cut those down by half, please, Mr. Anderson, for Ms. Jaballa's review time?
Yeah, so 2 hours, Registrar.
2 hours on this item, yes.
Yes. I'm grateful. Unless there's anything else on that item, I think that takes us on to item 8. 2 emails out, telephone calls, 6 long emails, etc. The point taken here is that, well, what's odd about this is that item 8 of the bill of costs is actually just 2 emails out by Mr. Brooks at the rate of 370 dirham. So we're not entirely sure we understand this dispute and the points of dispute.
Mr. Shaheen, would you like to clarify the points in dispute made in regards to this line item?
I'm not on a particular line, but I'm again going on the general basis. 9 lawyers working on a jurisdiction application, according to page 159 of the hearing button. 9 lawyers, and all their costs are added up together. So I'm disputing the fundamentals of it, the very logic of it. Item by item, I have given my comments. I'm not adding anything more now.
We're asking for clarification on this line item. We're not asking in general. We're just asking. Sorry?
Once I see the skeleton argument, I'll be responding.
We're not looking at the skeleton argument, Mr. Shaheen. We are looking at the bill of costs, and we are asking in regards to the reply you've already made. You've already responded. So we're just asking you to clarify the response you made in their bill of costs.
Nothing more to add,
That's all we're asking.
Nothing more to add. We already made our submission.
If you don't, Mr. Shaheen, if you don't provide a response, then I'm going to ask that the costs be allowed in full. Because if you're not going to clarify, and I'm not going to understand your submissions, then you're causing damage to your client. I'm asking you to respond. I'm asking you to respond to clarify a point you've already made. That's all I'm asking.
I already made my submissions. Despite my application for stay being dismissed, I'm fully cooperating with the procedure. I'm sitting here, and there is a skeleton argument submitted. I'm not even being the courtesy of being given a copy has not been shown to me. I have a right to respond to that, and my submission is hearing should have taken place after that. But Madam decided to go ahead. I'm still cooperating with it, and whatever submission we have made, we stand by that.
Mr. Anderson, I'm going to allow line item 8 in full on the basis that there is no clarification provided.
I'm grateful, Registrar. Item 9 is just a routine correspondence point again, as is in fact item 10. So I just asked for those to be allowed in full as well. Okay. And then item 11 is the next sort of substantial one. 4 hours, 48 minutes for Mr. Brooks and 10 minutes for Mr. Dylan Malone. You can see this is schedule 2 of the bill of costs, Registrar, and what these costs relate to is discussions with the client, finalizing the witness statement for the application, preparing a statement of costs, and sort of generally preparing for that hearing of the application to set aside. The point taken by Ms. Khoury is that we've already included some costs in relation to drafting the witness statement in a previous item, but we've now attributed 2 hours to finalising it. But the point we've made in response is that 2 hours to finalise a witness statement is plainly reasonable. We say, given its importance and the complexity of the matters in issue, And the second point made by Ms. Khoury is that a total of almost 5 hours for one additional cost statement seems to be claimed. But as you can see from the schedule, the 5 hours isn't just relating to the cost statement. It's there's an hour for preparing a statement of cost, but there's loads of other entries in relation to documents as well, including considering outcome of discussion with the defendant, updating and finalising witness statement in there. So we're not, as the points of dispute seem to suggest, trying to claim 5 hours for a cost statement by any stretch.
Mr. Shaheen, do you have anything to say in response?
Already mentioned it's a repetition, madam. It's already claimed in the previous paragraph, same submissions. So it's completely to be disallowed.
Mr. Anderson?
Well, you have my submission on that, Registrar. It's finalising it doesn't mean that it's identical to a cost that's been claimed before. It's just work on the same document, but obviously in a different item.
Okay, Mr. Anderson, I would like those hours cut in half as well.
Grateful, Registrar. Item 13 in relation to correspondence. There is a point. Obviously, there's 3 routine emails, which is the 555, but there is a point taken that the long email for which we claim 30 minutes, the Ms. Khoury says isn't a particularly long email because it reiterates RDC 7.20, but that's something of an inaccurate statement, because it's not just 30 minutes for drafting the email that sets these points out. It's reading the emails that have come in, considering them, and then drafting a response to them. And we say 30 minutes for doing that is completely reasonable, and there's no basis for reducing that, because it's obviously an important point about service.
Mr. Shaheen? The 30 minutes to review an email?
Yes, 30 minutes is not required for it. It's a very simple email, only referring to one provision of the RDC 7.20, which wouldn't take more than a few minutes as our submission on this.
How many minutes is few in your view, Mr. Shaheen? How long would it have taken you?
10 minutes, maybe.
We can say 15 minutes, please, Mr. Anderson.
Then item 14, Registrar. This is a series of costs that are claimed, totaling 6,475. The criticism here in the points of defence is the points of dispute is that the defendant has set out multiple instances of giving advice on the same grounds and claims repeatedly, and it's said that that's unreasonable. But we say that's obviously not a basis for reducing costs, because advice needs to be given on a continuous basis in a case like this, as matters develop and as new points arise. The other point as well is that it was a complex application. So at this point, this is in relation to the application to set aside service of the claim form and disputing jurisdiction. And that was a complicated application, because it involved questions about whether there had been valid service, the substance of the law of jurisdiction, and also the question of the impact of the parallel proceedings in the onshore courts as well. So all those times we say reasonable and proportionate, given that they were complicated issues. It was an application that involved more than one ground. In fact, there's 4 grounds that are cited in the points of reply. So the time spent there ought not to be reduced, or ought not to be reduced materially, simply because advice was given on more than one occasion on what was a very complicated point.
Mr. Shaheen?
Yeah, madam, it's a ground is claimed that giving advice, but giving advice on the same matter again and again, we are not supposed to be slapped with a cost for that. This is our submission on the first part. And it's about long emails, then telephone calls, email out one telephone call. This is what it is written. And under paragraph 10.2 of our submission, we have stated it clearly that every time the preparation of the email is starts separately. Then just for sending the email, just as pressing the send button, there's another 185 telegrams. So that's to be completely disallowed. That's from the beginning, we are stating that. Throughout our submissions, we have maintained that position. And 10.2 explains why we are objecting to that. And here again, giving advice or the same advice several times, we are not supposed to pay the cost for that. If the bank wants to have the luxury of getting the advice several times, they have to bear it, not us. So
Mr. Anderson, any submissions to respond to?
Just to say, Registrar, that it's the reason the bank's having to take this advice is because it is facing a claim which ought not to have been brought in the DIFC, as the Court of Appeal ultimately held. So it's been put to the cost of having to take this advice by a claim that ought not to have been started here, and it shouldn't be penalised, we say, for having to have taken that legal advice, which ultimately was correct, as the Court of Appeal held.
Mr. Anderson, I'm going to ask for a 20% deduction on this line item.
To 20% deduction on the total cost claims, Registrar. I've got that. Item 15 is then just a routine correspondence point. Item 16 includes a routine correspondence point, but then there's also a separate point here about the time claims apparently being redundant, because Mr. Brooks discussed the out-of-time claim form on 2 occasions. Well, I think the short point here, Registrar, is that there were 2 conversations. We've explained it in the points of dispute. There was a conversation between Mr. Brooks and London Council about this, and then a conversation with Mr. Brooks and the client, updating the client on the conversation that he had with council. So we say there's no basis for reducing that, because those were both obviously necessary conversations to have, and the sums claimed are very small, 555 dirham.
Mr. Shaheen?
It's the same discussion, same counsel on the claim form, once 24 minutes, another time 18 minutes. How many times they want to discuss the same claim form of the question, and why should we pay for it? So it's completely to be disregarded, the first part of it. And about 185 dirham per email I already submitted is throughout the document. I'm seeing this 185 in every item, and we have given clear details in article and paragraph 10.2 why it should be disallowed. So this is to be completely disallowed, the 555 and the 185. Repeated discussions, maybe 555 can be reduced by half, because 2 discussions on the same point, claim form. And out of time, this is one issue.
What do you mean out of time?
That's how they have discussed the out of time claim form.
Out of time claim form, okay.
Only for that point, how many discussions, and 24 minutes, 18 minutes, again and again, this is a grievance.
Okay, Mr. Anderson, would you like to tell us how many times an out-of-time claim form can be discussed?
Well, Registrar, my point is that it's the key point is not discussion of the same thing with the same person. It's the solicitors discussing with counsel and then updating the client on it. That's so.
And the first time it was discussed was with the client, I'm assuming, was with the counsel, and then with the client.
I think it's the way around. Sorry to interrupt you, but I think it was the
other way around.
Yeah, the solicitors discussed it with counsel, and then afterwards, obviously, the solicitors updated the client on what had been discussed with counsel in terms of advice, etc. We say it's very standard.
Okay, I'm going to ask for a 15% reduction on this point.
Is that 50 or 15?
15. 15.
Okay, then item 17, another small claim for 370 dirham. The point taken that this appears just to be an email serving the acknowledgement of service, and we say it's not just that email that we're claiming the 12 minutes for. It's also the filing of the acknowledgement of service, preparing the email, checking that the acknowledgement has been filed, and then actually the process of filing it. We say 12 minutes for doing all that, claiming reasonable.
Mr. Shaheen?
It's just a very simple email, madam. It is just serving the acknowledgement of service. It will not take more than 2 minutes. By any stretch of imagination, not more than 2 minutes, just to serve
But
an acknowledgement.
it doesn't appear to be just an email. It seems like there's more. There's the filing included. So the filing on the e-registry. I am actually surprised it only took them 12 minutes to do that.
The claim is for email 12 minutes, Your Honor. And the email is only serving the acknowledgement of nothing.
But
more
it
than
doesn't, it says undertaking steps to file acknowledgement of service. So to file it, I can assure you it takes more than that.
that claim later on. Initial claim, if you look at it, madam, was 12 minutes for an email. And that is where I said one email just to serve the acknowledgement, it will not take more than 2 minutes. So then came with an explanation, the time that is taken somewhere else, but that's not the original claim. That's an afterthought. The original claim is just the email. The ground on which the cost is claimed is just an email. And the email I'm seeing in front of me, it's just serving the acknowledgement, nothing more than that. And I wouldn't spend more than 2 minutes for that.
I would tend to agree, Mr. Shaheen, but if Mr. Brooks has spent time filing the acknowledgement of service and has not billed it later down in the items or in the line items, I don't see how them clarifying it is an issue.
That's not the ground on which it was claimed originally. The ground on which it was claimed was just an email. With all due respect, I'm not on technicality.
Mr. Anderson? No, I mean, Mr. Anderson, would you like to respond?
Just to point out, the bill of cost does make clear one long email, but then also, as you say, Registrar, undertaking steps to file acknowledgement of service. You know, we've confirmed that it's not just the email; it's also filing and checking the acknowledgement.
But this is the initial bill of costs.
Yes. Sorry, yes. This is in page 16 of the bill of costs. Yeah.
Okay. Page 16. Yeah. I'm going to allow it in full.
Great for Registrar. Item 18 then is a bit more substantial, and this is work done on documents as set out in Schedule 3 of the bill of costs. That might help to have that in front of you, Registrar.
Sorry, which page again?
This is page 194 of the bundle, Registrar, Schedule 3.
Okay, yes.
So if you just sort of scan down there, you can sort of see the types of work that have been done in relation to this particular item. It's quite a lot of time, but it relates to what was happening with the onshore proceedings, and part of the times claimed here relates to having to translate what was happening in the documents that were being created in the onshore proceedings, so that they could then be put in front of the DIFC courts. And we say that was reasonable and proportionate, because one of the arguments being run was that there was res judicata, in the sense that Ms. Khoury's claim had already been decided by the Dubai courts, and so she shouldn't be allowed to run it again in the DIFC. So there was a need, we say, a reasonable need to translate those documents.
Sorry, Mr. Anderson, just to stop you on that point, on the res judicata point, was the argument specifically in regards to jurisdiction?
No, that I think, I'll just get up Lenny's order. I don't think that was, well, I think it was a reason for staying the claim on jurisdictional grounds, or if the application was DIFC court doesn't have jurisdiction, but if it does have jurisdiction, it should decline to exercise it, or it should stay. And I think that was the basis for saying for substantiating that argument, that it had already been decided in the onshore courts. But just picking up item 18, Registrar, as we understand it, not all of these times are disputed, in fact, by Ms. Khoury, but just looking at what is said in the points of dispute. The first point is that almost 90 minutes have been spent for discussions regarding translation of the Dubai court file over the course of 15 days, and they say that's not reasonable or proportionate. So that's the first point, and we say it was, because it was obviously highly important to what was then going to be said in the DIFC court. Then a criticism is made of an hour spent considering the skeleton argument, reviewing the order, and considering possible appeal of the costs order, conferring internally. Again, we say it's completely reasonable to spend an hour considering the order that was eventually made, setting aside the default judgment. And one of the things that had to be considered was whether the judge's order for costs in the case was something that was capable of appeal. And ultimately, it wasn't appealed, but it was something that we say was reasonable to consider. And just one point to confirm on this as well, Registrar, is that just to confirm, we haven't included in this any costs in respect of the onshore claim itself. That is a criticism that's included a few times, but just to clarify, these are all costs that are properly incurred in the DIFC proceedings. So it's only those points that really seem to be challenged. So it's not a challenge to the entirety of the 35,817 dirham. It's just, it seems, a couple of smaller points about translation of documents and an hour to consider the skeleton argument. So if there is going to be any deduction, we say it ought not to be to the whole figure, but only those individual points which are set out in Schedule 3.
All right, I'm just going to look at Schedule 3 again. Sorry, bear with me.
Of course, Registrar. The considering skeleton argument when Registrar is the third one. Mr. Jabala spending an hour considering skeleton argument. And then there's not many times, you can see there's only a few times in relation to actually arranging translations, etc.
The first item on translation I can see is the one on the 12th of September for 24 minutes, Mr. Brooks' time.
Yes.
And then trying to find another one. And I don't see any other translation point. Mr. Anderson.
There's one just two above that, Registrar, on the 9th of September as well. Just 12 minutes.
Oh, conferring internally. Okay.
Yeah, but I think you're right. I think those are the only ones.
Mr. Shaheen, any specific points to make?
Yes, Madam, highly exorbitant. And again, I repeat, how many people involved? 1, 2, 3, 4, 5 people involved in this. That's what my first initial submission was. Why 9 lawyers involved in this to discuss a jurisdictional issue? And here, 1 hour 30 minutes goes perpetually only for discussion regarding the translation. Even the whole translation wouldn't cost that much. And then again, it's disproportionate to matter in issue, and the defendants, I mean, 1 hour was spent on considering skeleton argument, reviewing order, and considering possible appeal of cost order. See, at that point, there was no skeleton argument, there was no consideration on cost. How can it be added? I don't understand. So completely irrelevant. Then again, the submission by the defendant for 9/9/2021. Preparing the files of all the engaged in the issuing the claim, converting all documents into PDF format and adding signature and dates to the claim form. So this is all converting the document with press of a button, it gets converted into a PDF. What is there to be charged for that? And adding the signature and dates to the claim form. Is that something which is so time consuming, purely a clerical job? And uploading and submitting by the court e-filings and CA pleading expert reports and judgments readiness for, there was no expert report in the case at all, never. It's a jurisdictional issue, Karim Basis. It's also puzzling and there was no such filing made. See, multiple instances are there where they are considering the time spent before the Dubai mainland court and asking for the cost in the DIFC proceeding. That's exactly what is happening here also. Whatever time they spent on that case, they're asking for the cost here. And they're trying to defend that the Dubai court proceedings were a central issue to this claim. It was wholly reasonable and proportionate to the consider the Dubai court file and request a translation of the documents. Okay, a request for a translation of a document to English, the translator's charges are there, but nothing more than that. All the time you spend on expert reports and whatever proceedings happen, before the Dubai court are not to be charged in the DIFC court. That can be discussed there. The matter is under stay. No proceedings are happening before the appeal court now. So entirely irrelevant to the issue in hand. There is nothing related to the jurisdictional argument here. And they have mentioned about res judicata. Res judicata comes only when the judgment is final. This is pending before the appeal court and it is stayed. There is no res judicata here, and that was not the consideration before the DIFC court, only on jurisdiction. So completely irrelevant, whatever time they have spent. Only thing that can be allowed is the translation charges, which they are claiming separately. So the entire 35,817 is not pertaining to this case, not relevant, entirely to be dismissed.
Yes, Mr. Anderson.
Yes, Richard, just a couple of points. In relation to the point about the number of legal representatives who worked on this, you can see from the bill of costs itself that it's mainly Mr. Brooks. Everyone else is just sort of putting in very small hours. But as we understand it, the Miss Khoury had during these proceedings 8 legal representatives or 8 separate legal representatives representing her as well. So we say it's a bit rich to be making that point. But in any event, most of the work is done by Mr. Brooks. In relation to this individual item in the schedule on the 9th of September, preparing the file, etc., it's only 40 minutes of Mr. Basisso's time, what it involved was it wasn't just a purely administrative task. It was creating a sort of document, including the expert reports which had been filed in the onshore proceedings. It wasn't a question of expert reports in the DIFC. It was expert reports in the onshore proceedings, which had to be translated and put before the DIFC courts. They were exhibited to a witness statement that went before the DIFC judge. So it wasn't a straightforward administrative task putting all of those together and then putting them before the registry, uploading them to the registry so that they were before the court when it came to consider the application. And they were, we say, highly relevant to that application as well. So it's just a short entry of 40 minutes, but it shouldn't result in a substantial decrease to the overall cost claim for this particular item, we say.
So I'm going to allow in full the first 9th of September one, conferring inter alia regarding the translation of the Dubai courts proceedings, 12 minutes of Mr. Brooks' time. For Mr. Basisso's time on the 9th of September, I'm going to take that down to 25 minutes. And the second item on translations for Mr. Brooks, which is the 12th of September, arranging translations, attending internal discussion. I'm going to allow that in full. And I don't recall if this was a point in contention, but on the 13th of September, reviewing Dubai court judgments and requesting revised code for translation, 35 minutes of Mr. Basisso's time. I'm going to take that down to 20 minutes. Separately, on Ms. Jabala's consideration of the skeleton argument, I'm going to take that down to 30 minutes as well.
There was no skeleton argument.
Sorry?
There was no skeleton argument at that point.
I'll take instructions on that, Registrar. I'm sure there was. We wouldn't be claiming for time in relation to a skeleton argument that didn't exist, but I can just confirm exactly which skeleton it was, because as you can imagine, there were quite a few skeletons in this case between when it was filed and obviously the Court of Appeals judgment. I assume it's the skeleton argument in respect of the application to set aside the default judgment.
I believe so as well, because all the reference here is to part 12.
Yes, exactly.
So we can have this specific if you're instructing solicitors going to give us the exact reference for Mr. Shaheen's peace of mind.
Yes.
But I don't think it takes an hour for her to consider a skeleton argument, so I've taken that down to half an hour. I think that concludes everything in respect to this line item.
Yes.
One more. Proofreading, amending, and finalizing the Part 12 application, 26th of September, an hour and 42 minutes for Mr. Brooks. If we could run that down to an hour, please, Mr. Anderson.
Yes. Yes, fine. Okay, well, that then takes us to item 19. Translation. This is essentially the same point. These are disbursements. I think these are the fees for having the documents translated. The point made seems to be that whether or not this actually relates to the DIFC court proceedings or the onshore proceedings, but as I've explained, they did relate to the DIFC court proceedings because they were exhibited to Mr. Brooks' third witness statement in support of the argument that the claim was res judicata. So we say those were costs that were reasonably incurred. They formed part of the argument that was before the DIFC court, and there's no reason not to allow them as disbursements.
Mr. Shaheen?
Yes, madam. First of all, there was no arguments on res judicata. It's completely baseless. Res judicata is only when a final judgment is given by a court, and here the court has stated the matter is still pending there. So there's no final decision, and there is no judgment on res judicata. It was not the purpose, it's for the purpose of jurisdiction. That res judicata argument was not at all required, and it's completely out of place and baseless. So such costs, if any they incurred, are not to be put on the claimant here. It's unnecessary.
So sorry, just to clarify, Mr. Anderson, these are disbursements. These are the actual translator's costs, essentially, for getting those documents translated. And we have those invoices.
Yes. Yeah.
My point is not relevant to the case. It's not relevant to the matter at all. The judicata is not an issue that was being considered by the court. It's only jurisdiction.
My instructions on that, Registrar, that it was a point that was argued res judicata in the hearing.
Would you like to take us to the reference in Justice Glennie's judgment on that argument?
I don't
have
know.
The reference.
I don't know if it was in Justice Glennie's judgment in the end. I was trying to find the reference for it. Well, in fact, I think these would have been in relation to yes, no, I don't think I'll take some instructions on that. It was argued, but I don't think it was dealt with in Justice Glennie's judgment. My recollection of reading the judgment. Just having a quick look at it. No, I don't think it did feature in the judgment of Justice Glennie, Registrar, but it doesn't, in my submission, detract from the fact that it was taken and argued in any event. He ultimately he wouldn't have needed to decide that point because he did set aside service of the claim form and declare that the DIC court didn't have jurisdiction as well. But because it was a point that we took and it was argued, we do say that it was a disbursement that was properly incurred.
Before I make a decision on that line item, what is the difference between 19 and 20? Are those two different sets of documents?
Same. Even the explanation says refer to the above.
Yeah, I think they must be two sets of documents. I can obtain instructions on the exact difference between them, but they would have been, I think, separate documents. Yes.
The volume of documents, Mr. Anderson, how big was this file, Mr. Byford's file?
I will check that, Registrar. I'm seeing if I have a copy myself.
I haven't seen one, so.
I don't have copies, Registrar, but I'm just taking some instructions on that.
We can move on in the interest of
Yeah,
time.
should we refer to that one? We'll make a note to come back to that, those disbursements. So then that would take us to 22. 12 minutes in respect of an email, as the bill of costs sets out, advising on the inaccuracies of the claim brought against the defendant and the options available. We say that's a perfectly reasonable amount of time. It's only 12 minutes to send a detailed email considering next steps, options, strategy, etc., and providing some advice as well. It's only a short amount of time. We say that should be allowed in full.
Mr. Shaheen?
I don't see any problem because 12 minutes for an email, though it's not a very detailed email, they have given an explanation, but whatever I'm saying is without prejudice again.
Right, we'll allow it in full.
Grateful. Item 23, similar-ish point. Obviously, we have the 185, which is the routine correspondence. In relation to the 555, as we set out in the points of reply, it's a telephone conversation, 18 minutes with counsel to discuss the claimant's response to the defendant's Part 12 application. So we say that 18 minutes, discussing the case with counsel again is very standard, reasonable, reasonably incurred, and not disproportionate.
Mr. Shaheen?
It's the same comments what we have given in paragraph 10.2 regarding sending an email, every email 185 dirham, pressing the send button, and that 555 dirhams towards an 18 minutes phone call. It's an internal discussion. I don't know whether actually it took place or not, whether it was necessary. I'm unable to comment anything beyond that. I'm only saying it's exorbitant.
I'm going to allow it in full.
Great for Registrar. Just coming back to your question about the size of the translated documents, my instructions are that there are about 50 pages of original Arabic documents that need translation on those disbursements. So my position, those 50 pages, that is 25 original and then 20, yes, but 25 original and then 25 translated pages, total 50, which went into the exhibit.
I'm not on the volume or number of pages, madam. I'm only saying it was neither required nor relevant to the issue.
I'm of the view it's required, because if you've commenced proceedings and you've made specific arguments before one court, the other court should be aware of what those arguments are. I would have certainly wanted to see them if I were the judge in this matter. So I can only assume that it was necessary. My only concern is with regards to how much translation needed to be done and whether the costs incurred are reasonable or proportionate. You said 50 pages, Mr. Anderson?
Yes, but 50 pages in total. Just to clarify, it's 25 pages of Arabic script that are then translated. And the documents that were translated were Ms. Khoury's claim form onshore and then the bank's response. So obviously really crucial documents for the DIFC courts to see. But yes, 25 pages worth, and they were disbursements, which we say, because they're disbursements and they were reasonably incurred, they should be allowed in full.
And do we have a response from your instructing solicitors on the difference between the two line items? Or is the previous one the claim form and then the bank's response is the second one?
I'll check that, Registrar. I imagine that's probably correct. But certainly we're not translating the same documents and trying to claim the,
yes.
claim the cost documents.
Okay, I'm going to allow them in full.
Then we come to item 24 then, Registrar, which is 2 hours 48 minutes on documents. You can see from the bill of costs that this is reading and considering the evidence and response, essentially, and then drafting a reply statement. The point made in the points of dispute is that it was only a short reply statement, so it shouldn't have required 2 hours 48 minutes. But as you can see from the bill of costs, it was only 36 minutes that were spent drafting that reply statement, and the remainder of the time is essentially reading and considering the evidence and response that Ms. Khoury had filed, which obviously needed to be considered carefully, in particular because the bank's case was that that evidence contained various incorrect points of law as well. So it was necessary for the bank to correct that in its evidence, even if it was a short document. So we say, you need to look at the bill of costs on this one. It's not over 2 hours to draft a 2-page statement. Most of the time is considering what's been said in response, which is obviously a lot longer than 2 pages.
The 24.
Mr. Shaheen?
Highly exaggerated. The 36 minutes would have been reasonable. This is claiming more than that only for the internal discussion, strategy discussions and all that. It's a 2-page witness statement end of the day. 36 minutes I can understand to review the pages what other side has submitted and then to draft it. But 2 hours 48 minutes is not acceptable. It's very unreasonable and disproportionate.
Mr. Anderson, if we could take this down to an hour and 45 minutes
Yes, Registrar.
for the reviewing of the evidence and answer and for the drafting of the witness statement and response.
Yes, so for everything, yeah.
Yes.
Okay, then item 26. Yeah, this is a very small point. It said it's unclear as to which matter the advice relates to. It's disbursement paid to London Council, and it was a small amount of disbursement in respect of advice that we confirm related to this claim, advice by telephone. So we say that particular item should be allowed in full.
Do we know what the nature of the disbursement is?
Yes, it was fees paid to London Council in respect of advice by telephone in relation to Miss Khoury's reply evidence on the Part 12 application. So it was just a conversation about that.
Mr. Shaheen, anything to say in response?
It's entirely unclear whether it was related to this case or it was an advice completely different. I don't have anything in front of me to comment on that, so I can't accept this cost on the claimant.
I'm going to allow it in full, Mr. Anderson.
Great. Then item 27. This is in relation to telephone call and a long email. Trying to work out where in the bill of costs it comes. See, yes, sorry. So item 27. So yes, one long telephone call discussing judgment and reply evidence, and a long email preparing non-routine email regarding the investment agreement. What the point taken in the points of dispute is that the judgment had been issued about 3 months before this, and we were discussing that with the bank. But the point that the bank makes is that the description, as is clear in the bill of costs, is discussing the judgment and the reply evidence as well, and the reply evidence had been filed on that day that time was recorded. So it's not a sense that there's a phone call just to say, oh, remember that judgment 3 months ago. It's discussing that judgment and the reply evidence together, and the reply evidence had been filed that day. So we say a 30-minute call with the client on the day that important evidence is filed is not unreasonable or disproportionate.
Mr. Shaheen?
Yes, madam, it's a redundant cost. After 3 months from the date of issuing the judgment, again, if they keep on discussing the judgment or any points in it, why should the party pay for it? So it's completely unreasonable to claim it as part of the cost, whatever they did after the judgment, 3 months after the judgment. And there's nothing tangible, one long telephone call, we can't assess it even.
So, Mr. Anderson, am I correct in assuming, and I'm just looking at the replies document, 925 is the cost for the phone call, and then there's the 185 for the long email. I'm not sure if the math adds up.
It's, yeah, if you look at the bill of costs, Registrar, it's 925 is for the long telephone call, it's 30 minutes. And then there's a long email, which is 370 because it's 12 minutes.
Okay.
So it's just a 30-minute call with the client to discuss reply evidence that's come in that day. And we say that's plainly reasonable and proportionate.
I would like that phone call to have only taken 15 minutes, Mr. Anderson, considering it was 3 months from the date of issue.
I'm grateful I have that point, Registrar. Item 28, there's various documents you'll see, Registrar, total sums claimed 9627. We say this again, it appears that there's been a bit of confusion about what the bill of costs actually says, because these aren't costs of drafting that 2-page witness statement, which is what the sort of points of dispute seem to suggest. They relate to principally, as you can see from the bill of costs, a judgment that was handed down by the Dubai Court of Appeal in the Dubai proceedings and how that impacted the position in the DIFC. You can see that from the first of the entries under documents, liaising internally regarding appeal judgment and implications on DIFC proceedings, considering appeal preliminary judgment, reviewing and amending the English translation of the preliminary judgment, etc. What we say is basically the points made and the points of defence appear to be aimed at the wrong target. This isn't hours and hours that we're spending on relation to this 2-page witness statement. It's different costs as are described in the documents section of that particular item.
Mr. Shaheen, would you like to respond?
Yes, madam. It is a repetition of what is already covered in item number 24. There itself, they have claimed 2 hours 14 minutes, which itself, according to me, is exorbitant. And then again, they are discussing about a case which is in another jurisdiction, which is not related to the matter which was handled by here. The case is related, but the costs are to be submitted there, not here. And again, spending another 3 hours and 30 minutes, 1 hour 50. End of the day, it's a 2-page witness statement. So even the first 2 hours 48 minutes, which I can consider 3 hours together, but nothing more than that. How can we charge double, and that too on a matter which is irrelevant? Again and again, the same discussions for a 2-page witness statement. So it's highly unreasonable to come up with such claims.
Mr. Anderson, anything to say in response?
Just to point out again, Richard, very little of the time claimed here relates to that 2-page witness statement. There's clearly a key development onshore, which is a Court of Appeal decision, and that needs to be considered and its impact on these DIFC proceedings considered.
Charging twice.
And what is Mr. Basiso's involvement in this line item? So is he advising on the Dubai court's proceedings?
Okay, so he has 3 entries under the documents. His first is liaising internally regarding the appeal judgment. Part of the reason for that is that there are within Tamimi, there are 2 different firms operating on the 2 cases. There's an onshore team doing the onshore proceedings and the DIFC team doing the DIFC proceedings. And Mr. Basiso has to liaise with the onshore team to have an update on what's going on, essentially. But also because I think partly because he's an Arabic speaker as well, he does a lot of the work in reviewing the onshore judgments for the purpose of these DIFC proceedings. You can see that that's part of what he does in the first line item. He's also reviews the translations as well when they come in, and also reviews the 7th of the 11th 21 reviewing submissions to the DIFC courts and undertaking minor amendments. So his work is principally in sort of checking that what is being said to the DIFC courts in respect of the onshore courts is correct and accurate.
But he is not part of the onshore team, essentially.
No, no.
Can we please, Mr. Anderson, cut these hours down to half for Mr. Brooks and Mr. Basem?
So essentially cut the entire cost.
Essentially, yes. Yes. More sense.
Covered the item number 24. It's a repetition of that same witness statement.
That is not a repetition in my view, Mr. Shaheen. Mr. Anderson has already responded to that point.
If I may, Registrar, item 29. This is another disbursement fee for translation. The point taken was that Ms. Khoury didn't know what it applied to. We've clarified in the points of reply that it was a translation of the order of the Dubai Court of Appeal order on the 3rd of November 2021. So now that
I'm
we've
going to
clarified,
allow it. Yeah.
Item 30, there isn't actually, as you'll see, there's sort of a blank box there. So we say there's no valid point of dispute there. It's picked up, but there isn't actually a challenge to it, so it should be allowed.
Agreed.
And then item 31, in relation to the 2 emails out, those are routine correspondence, so we say those should be allowed. In relation to the 1 long email, again, it's just a 12-minute email, but we have pointed out in the reply that they all essentially concerned liaising with counsel and also reserving counsel for the hearing, advice as to bundles, etc. And the long emails, the bill of costs makes clear is in regards to the upcoming hearing. So yeah, these are very small sums, 12 minutes. We say there's no reason not to allow them.
Okay, let's allow that.
I'm grateful. And then 32, again, this is a more substantial one. Documents, 7 hours from Mr. Brooks and 27 minutes from Mr. Basiso. The point again here seems to be that some of the items claimed relate to the onshore proceedings, but again, you have my submission on that, Registrar. Just because they relate to the onshore proceedings doesn't mean that they can't be claims, because they're not costs that have been incurred in running those proceedings. They're DIFC costs, but obviously because of the overlap, they have to be incurred in these proceedings because of that point about res judicata. We've set out here that what these costs particularly relate to are some particular aspects of the onshore claim, in particular some evidence that had been filed in relation to, or some expert evidence that had been filed. And you can see from our point of reply, the Dubai court had permitted an appeal and ordered that a 3rd expert report be commissioned, dealing with the losses, which a claimant was also trying to seek under the same in the DIFC proceedings. So the expert had given some findings on what the losses apparently were, and obviously that was highly material to the identical claim, which Ms. Khoury was advancing in the DIFC. So we had to obviously translate and read that expert report so that we could update the DIFC courts on the latest happenings in the onshore proceedings with regards to the remedy that Ms. Khoury was seeking. On that basis, those 3 items of the document section we say ought to be allowed. And in particular as well, it's worth pointing out, Registrar, that it seems that it's only those items on the 18th of January, 19th of January and 20th of January that are challenged. So all of the other work on documents under that section doesn't appear to be challenged either. And they total 36 minutes and 27 minutes. So 63 minutes in total of time challenged.
Mr. Shaheen?
Relevant and completely out of place on pertaining to the Dubai mainland court nothing to do with the DIFC code. And DIFC code never considered even one point on the merits of the case. The only issue being considered was on jurisdiction. There was no need to bring a whole lot of expert reports and other documents from the Dubai mainland court here, because we never entered into the merits of the case. So it's only on the jurisdiction, it's like a preliminary hearing. So this is completely irrelevant and it should be dismissed in total.
Mr. Anderson, I will allow a 15% deduction on the entire line item.
1-5, Registrar.
1-5.
I'm grateful. Then 33 is another disbursement. Again, disputes on the basis that they didn't know what it applied to. We've confirmed that it was a translation of the banking experts report that I've just referred to, which needed to be placed before the FC court. 35 is then disbursements to council. It's the disbursements to council that are challenged in relation to this item. The point taken, it's unclear as to which matter this was provided for, and said it should be rejected, but it was council's brief fee to represent the bank at the hearing before Justice Glennie. And we say that brief fee for a hearing of this importance and this magnitude is and in the context of $6 million claim is plainly reasonable and proportionate, and because it's a disbursement should be allowed in full.
Mr. Shaheen, now that the matter is clear what the disbursement is for, do you have any submissions?
We are not, there is no way to check whether this is really pertaining to this matter in hand. It's not a $6 million claim to be looked at. It's only an issue on jurisdiction which was being discussed. And these are all exorbitant and nothing to show that this was pertaining to this claim event. That's our submission here.
This is counsel's fee, Mr. Shaheen. Counsel's fee to represent the defendant at a hearing to set aside the default judgment your client obtained.
Anything supporting document?
There is I've seen it, so it's there. This is counsel's fee. So Matthew Watson, counsel, appearing at the hearing. This is his fee. Is there anything in specific you would like to say to that?
Sorry, I have not seen any document pertaining to this as an invoice.
I will allow it.
I'm grateful, Registrar. Item 36 is the next one. Again, the three emails out, 555 are all routine correspondence, so we just ask that those be allowed. In relation to the long email, it's a 24-minute email regarding the hearing bundle index. The point made and the points of dispute is that it wasn't a particularly long email that required 24 minutes of drafting because it clarified some of the exhibits. But what we have said is that what Ms. Khoury had done was seek to modify the legal bundle index to put in a bunch of factual and legal exhibits as well. And there was obviously disagreement about whether or not that was appropriate. So we say in that context, and given that those exhibits had to be considered as well as part of that discussion about what should go in the bundle and how it should be indexed, those 24 minutes weren't disproportionate or unreasonable.
Mr. Shaheen?
Yes, that's the argument is unreasonable, it's disproportionate. It's just an email clarifying some of the exhibits. So 24 minutes is not required, and there's the 3 emails out. Again, paragraph 10.2, I have explained it.
A 15% deduction, please, Mr. Anderson, on this line item.
Is that just on the 740 registrar, with the 555 being routine correspondence?
Yes, just on the 740.
I'm grateful, registrar. That brings us into item 37. Again, two emails out as routine correspondence, and then there's a telephone call and a non-routine email as well. So I say that one of those 370s ought to be allowed as routine correspondence. Then, in relation to the telephone call and the email, you'll see from both the excerpt there and the bill of costs that it's telephone call is to discuss the upcoming hearing and the skeleton arguments, and the email is reading and noting comments within email received. It's all of this is sort of correspondence to do with the defendant's skeleton argument for the hearing before Glennie. Obviously, it was a detailed skeleton argument. It included 4 separate arguments as to why the claim should be dismissed. And we say in that context that two lots of one lot of 12 minutes, one lot of 18 minutes, 30 minutes spent discussing the skeleton arguments is not disproportionate or unreasonable.
Which item is it?
So this is a call between Mr. Brooks and counsel? Or is it with Mr. Brooks and the client?
I'm not sure if it is between Mr. Brooks and counsel. It might be with Mr. Brooks and the client. I can check that, but in my submission, it probably ought not to make much difference if they're discussing the skeleton argument before it's filed before the court. That would obviously need to be discussed both with the client and with counsel at the same time as well. And again, these are really small figures in the context of this claim as registrar.
Yeah. Mr. Shaheen, anything to say in response?
This is item number 37. It's only about what we have stated in paragraph 10.2, nothing more than that. Each email 185 dirham just to press the send button. That's how.
We already spoke about the emails. The emails, in my view, are completely normal in practice. So we can keep talking about the emails, but they're not going to make a difference. My concern is the phone call. Do you have anything to say in respect of the phone call?
We have nothing to verify that, and we don't even know whether it took place or whether there was actually relating to this case. I feel it's disproportionate and unnecessary.
I'm going to allow it to inform Mr. Brooks.
I'm grateful, registrar. Item 38. Again, one email of 12 minutes, non-routine, and then 2 standard emails. Just looking at. Oh, sorry, I'm looking at the wrong item. Item 38. Yes, it's a telephone call, 18 minutes, discussing further submissions filed by the claimant for 18 minutes. So Ms. Khoury had filed some further submissions. We say that 18 minutes to discuss the impact of those is plainly reasonable and proportionate. And then detailed email, 12 minutes. And that was, as you can see from the replies, it's liaising with counsel prior to the hearing. And most of these entries are liaising with counsel, getting ready for the hearing, which was coming up shortly before these costs were incurred, or shortly after these costs were incurred, I should say.
And these submissions were made at what point in time? Was it right before the hearing?
Yes, I think they must have been. Well, because the hearing itself was on the 21st. Yes, my instructions are that the submissions were filed just before the hearing.
Mr. Shaheen, anything to say in response? I can't hear you, Mr. Shaheen.
Same thing again about phone calls and emails. No means to verify, and I stand with what I said.
I'm going to allow it to unfold.
I'm grateful, Registrar. Item 39, one long email. So again, we say this is all essentially routine correspondence. The 2 emails out are routine. The long email, we've explained in the points of reply, it was to advise the court of an error in the claimant's supplemental note that had been filed at the court earlier that day. And in particular, that note concerned an allegation that service of the claim had been effected in May 2021, which was wrong, and the bank had to correspond with the court to correct that, and also point out that the claimant, Ms. Khoury, wasn't able to take that point. So it was obviously essential that the registry wasn't inadvertently misled on that point. And we say that incurring costs of a 12-minute email to correct the position for the registry ought to be allowed.
Mr. Shaheen?
One long email may be okay, but I have that dispute about sending emails and charging 185.
Okay, I'm going to allow it in full.
Grateful. Then item 40 is more substantial. This is Schedule 4 of the Bill of Costs. It's documents, 10 hours for Mr. Brooks and 3 hours 54 minutes for Ms. Fossafil. This principally, if you turn up the schedule, perhaps, Registrar, you'll see that all of this relates to the preparation for that hearing before Justice Glennie. The relevant page being 195. And just the point taken, the points of dispute is that the overall time for preparing for the hearing is disproportionate because it involves sort of 14 total hours of solicitor time. But the point that we've made in the points of reply is that this was not by any stretch of the imagination a straightforward Part 12 application disputing the court's jurisdiction. The skeleton argument itself was, as we pointed out, 10 pages, 45 paragraphs, and it advanced the obviously alternative arguments on setting aside the claim form, disputing service, saying that, disputing jurisdiction, saying that any jurisdiction shouldn't be exercised, and the res judicata point. It was obviously a highly important hearing because it could, as it did, result in the claim being completely dismissed. And the other point that we've made in the points of reply is that our costs, our total costs of the hearing were around 220,000 dirham, whereas Ms. Khoury's were about 180,000 dirham. So it's not wildly, poles apart. And in addition, we also had additional costs of preparing the bundle and things like that as well, because we were the applicant. So we say that overall figure, bearing in mind the size of the claim, the complexity of the issues, and the fact as well that this is all done by senior associate as well. We're not sort of trying to claim partner time in relation to all of this, even though it is obviously a very important and complex hearing. Means that there should, in my submission, be no or only a very small deduction to the total cost claim for that hearing.
Mr. Shaheen?
First of all, it's very exorbitant. And second thing is most of the items are already covered in the previous item. The exchange of emails, phone calls, preparations, all this is already charged and again duplicated here. So 23,570 is exorbitant is my submission. There's repetition also under that.
Mr. Anderson, I'm going to ask for a 20% deduction on this amount.
I'm grateful, Registrar. I think that then takes us to item 41, part 8 of our costs. This is cost of attendance. So what is quite a short point. What Ms. Khoury says is that this is a duplication because both the partner and the senior associate attended the hearing, and we've claimed for the partner's got Ms. Jabala's cost of attendance. But what we've said is that given that this was obviously a highly important hearing, and also given that we're not trying to claim any time in relation to Ms. Jabala in relation to the preparation for the hearing, it was reasonable for her to attend because it ultimately did result in the dismissal of a nearly $6 million claim, and that it was reasonable for both her and Mr. Brooks to be in attendance at that hearing.
Mr. Shaheen, anything in response?
If you look at item 34, preparing for an attending hearing 4 minutes is already there 6,290 claimed. And again, the same thing comes here. Attending hearing and post-hearing conference 3 hours 30 minutes. The counsel's fee is separately noted under 35.
Mr. Anderson, would you like to respond?
Yeah, just to clarify, Registrar, the item 34 is Mr. Brooks' costs of preparing for and attending the hearing, whereas item 41 is Ms. Jabala's costs of attending. So it's not a pure duplication. We're not trying to claim for the same solicitor attending. It's one is cost for the partner, one is cost for the senior associate.
Mr. Anderson, I'm going to ask for a 40% deduction, so 40.
I'm grateful, Registrar. And then 42, 43, and 44 are actually all just routine correspondence. So we just ask that you allow those in full.
Yep.
Cost has gone up. The cost has gone up from 25 to 205. 42.
One email out. Is that the line item you're asking about?
This is the 42 one email out and 205. Normally it was 185. I'm not agreeing on 185 either, but just pointing out that this fact.
Yes, I think if I can explain that, the reason is because it's a routine email by Ms. Jabala rather than Ms. Brooks, so it's 1/10 of her hourly rate rather than a 10th of Mr. Brooks' hourly rate.
Okay.
So the next significant one is item 45, total cost of 7,775 dirham, an hour and 6 minutes, Mr. Brooks, and 2 hours 48, Mr. Jabala. All this work essentially, as you can see the document section there, Registrar, all of this work essentially flows from the Ms. Khoury's application to the JJC and emails that she then sent to the registry, which my client had to consider and prepare correspondence in relation to it. The point here is that yes, essentially we had to intervene in relation to this correspondence with the registry to clarify what the actual position was. and there had to be a consideration of whether the JJC application affected these proceedings at all or not. So that was part of the costs involved, was considering that point and working out whether there was any impact on the Part 12 jurisdiction challenge. So what essentially this sort of work here in item 45 is we say in the reply, is progressive in nature and reasonable and proportionate, because it relates to an ongoing important matter that was likely to have an impact on the jurisdiction of the DIFC courts.
Mr. Anderson, before I ask Mr. Shaheen to respond, is there a reason why the majority of the time incurred on this was by Ms. Jabala? So
I think one of the points we've made elsewhere in the reply submissions registrar is that Ms. Jabala's involvement generally very limited in this case, which is, in my submission, a point to be commended, that the vast majority of this case is run by the senior associate. Ms. Jabala's involvement tends to occur where there are higher level strategic decisions to consider and where supervising partner involvement might be required. And given that these discussions relate to the application to the JJC, that's obviously a very important point, because it could potentially be determinative of jurisdiction between both the DIFC courts and the Dubai courts. So in the context of the bill overall, I think my submission would be that Ms. Jabala's time here was reasonable to incur and proportionate, because it is a very rare example of her incurring time on a question which was of very high importance to the claim overall.
Mr. Shaheen?
Yes, madam. First of all, initially the date was mentioned as 18/3 and we could not trace it. That's why we could not give details about the email. Afterwards, it has been clarified. It's in fact dated 17/3/2020. But it's all pertaining to the proceedings before the JJC, which is still pending there. So if the JJC decides in our favor, they will have to pay our costs. So it's not a matter to be decided in this court. It's not a matter to be claimed to the DIFC court. It's completely pertaining to the JJC proceedings. So it cannot be allowed.
Mr. Anderson, any points to make in response?
Just that our position is that if, as happened, Ms. Khoury had made an application to the JVC and then told the defendant about it and told the registry about it, it is unrealistic to not expect the bank to have to consider that application and how it might impact the fact that the DIFC proceedings were still ongoing. We couldn't not look at that and just sort of continue. So we, especially because what this dispute boiled down to at this time was a question of jurisdiction. Well, and obviously a reference to JJC is obviously critically important to that question. And the point was what the bank had to consider, what was the implication of the JJC having this reference on the ongoing proceedings. And that was a question that had to be considered by the bank, because it couldn't just proceed on the without considering how it impacted the jurisdiction challenge. Ultimately, the conclusion was that it didn't impact the jurisdiction challenge, but that was a step that had to be considered because Ms. Khoury had obviously raised it in the DIFC proceedings.
I agree that there should have been some form of consideration as to the impact on the DIFC court's proceedings. I just don't believe that the amount of hours it took to reach the conclusion that it did is reasonable and proportionate. So I'm going to ask that it be there be a 60% deduction on this amount, Mr. Anderson.
I have that, Registrar. Thank you. Item 46, again, a short point. This is, again, a point about disbursement in relation to council. We've confirmed there was a fee paid to council and what it related to was work in respect of drafting submissions, opposing the permission to appeal application. So, and it's again, as we say, it's a small disbursement. There's no reason not to allow it.
It's allowed.
Sorry, Registrar, was that allowed?
Yes, that is allowed, yes.
Oh, I'm sorry, I didn't hear you, thank you. Item 47 then, this is the same point raised by the defendant in relation to the detail of the emails. You can see that part of this, you can see from the bill of costs, relates to liaising with Mr. Watson's chambers. Oh no, sorry, that's item 48. 47, advising the defendant about the permission to appeal application, drafting emails relating to the permission to appeal application, and also considering costs of the appeal as well. So we say that the descriptions are there, they're in the bill of costs. The overall times claimed are reasonable and proportionate because it's an application for permission to appeal to the Court of Appeal. So having spent 18 minutes on a phone call, sent 5 emails, and also engaged in narrative 4 minutes for 2 emails out, we say is proportionate in relation to that application.
Yes, Mr. Shaheen.
Disproportionate, and we have raised that contention. It was said that supporting evidence can be produced at the detailed assessment hearing. To my knowledge, nothing has been produced. It has to be disallowed.
Mr. Anderson?
Well, obviously, the point about evidence being produced is that a lot of these emails will be privileged. That's the point of obviously the solicitor signing the bill of costs, is that where there are emails to the client, those are privileged emails, but the solicitors have confirmed that the costs were properly incurred by signing the bill of costs. So if that is the only basis of the objection, we say it's an unfounded one and that the cost should be allowed in full for this item.
The costs of the emails I will allow, and the telephone call as well. Well, I'll allow it in full, essentially.
I'm grateful. 48 is just 2 emails, one routine, one non-routine. So the routine email, we ask you to allow the 185. The non-routine emails, I was saying before, this was a detailed email to Mr. Watson's chambers, considering his fees going forward as well. And also the routine email was sent in response to the draft submissions. So we say that those 18 minutes of time corresponding with councils and council chambers should be allowed in full.
So then the emails in 47, those were to, I'd assumed that the to council, liaising with council. So Mr. Brooks' emails set out in item 47.
Yes, I don't think they all were. You just give me a second, Registrar, I can just double check. 40. So these are, I think, predominantly emails to the client and internal emails regarding on how to advise the client in relation to the permission to appeal application. So these are principally emails to the bank itself rather than to council. I apologise if that was my fault for conflating 48 and 47. But some of those emails concerned obtaining instructions about instructing council to prepare the submissions in response to the permission to appeal application as well.
I'm going to allow it subject to anything Mr. Shaheen has to say. Yes, go ahead.
Just one point, madam. It is emails I have made the general comment. Other than that, it's about discussion of the fee proposed by the council. As we lawyers, we always consider the fee discussion to be a non-billable item. We don't charge it to the clients or the other party. If they have to discuss the fee with the council, that's not something to be borne by the other side. So that email has to be completely disregarded.
I'm going to allow it. On the basis this is an email to council.
I'm grateful, Registrar. Next is item 49, which is principally a documents claim. But you can see that what is said in the points of dispute is that there's only one objection taken here, and it's that essentially there's a duplication of times, because what's said is that in the schedule there are repetitions of the same actions under different items which double the hours. It's a similar point to what I made earlier, that it's not a duplication per se, it's that both Mr. Brooks and Ms. Jabala were considering similar points. And it might help to just have a quick look at the schedule so that you can see that. This will be at page 197 of the bundle, Registrar.
Mr. Shaheen, anything to say?
There is duplication and repetition, and this one is disproportionate also. Again, it stems the root causes 8 counsels, 8 lawyers appearing in the matter, each one doing the same work and it 8 times billed to the other party. This is what's happening in the whole case. That's why I took Madam's attention to initially 9 lawyers for a jurisdiction application. So we don't accept.
You say there was duplication. Where is the other duplicated item?
Everybody is doing the same work. That's what I'm looking at.
Okay.
And it's taking time for the same matter. Rather than one person handling the matter, 8 people handling the same thing.
There's no 8 people on this matter. It's Mr. Brooks and Mr. Jabala, so there's 2.
It is written by them in the response. It is noted from the claimant statement of cause dated that the claimant's legal team. So our legal team were 8 and they were 9. Sorry.
But they're not saying that in respect of this item. It doesn't have to do with the other people. The only 2 people that were engaged on this line item is Mr. Brooks and Ms. Jabala.
It's the same action what both of them are doing. This is Lara.
No, it's not actually, because if you look at the level, so there's a senior associate with it, which is Mr. Brooks, and then there's Ms. Rita Jabala, who's the partner. So they're not doing the same thing essentially. One person is drafting and the other person is reviewing.
That's pretty much the same thing. That's my
No, it's
submission.
not actually. It's not. Absolutely not. No. I'm going to ask for a 20% deduction, Mr. Anderson.
I'm grateful, Registrar. So that takes us on to item 50. Again, one long email, one email out. The cost, just on the points of reply, there's a slight error here in that 555 is the total for this claim. There's actually 370 in respect to the long email, and then the standard 185 in respect of the routine correspondence. The long email is a 12-minute email. We've described it as preparation required calculation of the date of service, and we had noted that the Ms. Khoury had incorrectly stated the date for service. So what needed to happen was that there had to be a calculation of the date by which the bank's response was due, and then tell that to the claimant essentially. So it's correspondence about proper date of service with the claimant. And we say 12 minutes to work out what the proper date of service is, and then draft an email, send it to the claimant explaining that is plainly reasonable within 12 minutes.
Mr. Shaheen? You're on mute, Mr. Shaheen. I can't hear you.
Same submission regarding emails, nothing special about it. Too many emails to postmate costs.
Yes, I know that argument. Okay, Mr. Anderson, I will allow it.
51 then is an 18-minute email preparing detailed email advice. That's email advice, obviously, to the bank following the application for permission to appeal. Obviously, I can't describe the contents of that because it will be covered by legal professional privilege, but 18 minutes in respect of advising the bank on the permission to appeal application. We say, given the points I've made about the seriousness of this and the fact that it potentially is going to the Court of Appeal, is not disproportionate or unreasonable.
Right, Mr. Shaheen, 18 minutes to discuss the appeal with the client. Any objections?
No, that's okay.
Okay.
I'm grateful. Item 52 is routine correspondence again. I'd ask that be allowed. And item 53 is a small claim for documents. This is now the application for permission to appeal, but again, it's another example where actually looking at the reply, the box is empty. So as we understand, there isn't actually a dispute in relation to this.
Okay, Mr. Shaheen, I don't see a dispute, but unless we're missing something.
Yeah, the same routine objections, and plus it was all supposed to be produced at the detailed assessment hearing. Nothing has been produced. That's all. This item and the previous item.
Covered that. Mr. Anderson, if you would like to respond to that point again.
What was the point that, I'm sorry, was the point that we haven't produced evidence of?
At the detailed assessment, yeah.
Oh, I see. Well, our position is we can't produce all that evidence because part of it's privilege, but also the solicitors have signed a bit of cost confirming it's true, and it's very standard that is sufficient to give the registrar confidence that these are properly described. These
Okay, I'm going to allow it.
54 is another disbursement to council. It's the same point, registrar. This is just this fee relates to preparation of submissions opposing to permission to appeal. This is slightly different, obviously, because this is the application before the Court of Appeal rather than before Justice Glennie. So slightly more detailed submissions need to be prepared because obviously the Court of Appeal was not familiar with the background to the application. But in any event, we say that that fee of that disbursement of 5,745.54 is reasonable and proportionate for preparing written submissions on a permission to appeal application to the Court of Appeal.
Mr. Shaheen?
Yeah, from the explanations given, 54 and 53 pretty much relates to the same item, and the submission is exorbitant and there is duplication in it. Although the people were different, but it's the same item and it's highly exaggerated. 6,450 and then again 5,700. One applied to the permission to appeal.
Mr. Anderson?
Well, firstly, we say there isn't actually a dispute in 53, but in any event, 54 is a different point because it's council disbursements for council to draft written submissions, whereas 53 concerns the costs of reviewing the application on the solicitor side. So they're separate costs.
I'm going to reduce 53 by 20% and allow 54 in full.
Then 55 registrar emails regarding the draft submissions, essentially. Sorry, Richard, just one point on 53. Did you say 20% reduction, notwithstanding that there is no dispute before you by?
Yes.
Can I ask you whether you'd be prepared to revisit that in light of the fact that there doesn't seem to be any dispute by Ms. Khoury in relation to those figures? They're not. Then there's not, in my submission, there's not an overlap between 53 and 54, because what's happening in 54 is that council's drafting submissions, whereas 53, which we understood was not disputed, was the solicitor's cost of reviewing and considering that appeal notice.
My concern is if the documents have been drafted by council, does it really take 2 fee earners to review it again? Unless
Well,
my understanding is miscorrect.
I understand that, Richard. It may be then that that point is more directed to 55.
Okay.
Yes, item 55, which is the review of the submissions, whereas 53 is the review of the application for permission to appeal and the documents filed in support.
That clarifies it. Yes, thank you very much. And my apologies.
No,
sorry, yes, Mr. Shah.
55 is pertaining to emails. This is documents is different under item number 53. So it's not correct to say the point of dispute is not stated, but the entire thing is disputed. We have said it's all exorbitant. It has to be reduced to reasonable limits. That submission always remains.
Yes.
And what I pointed out, the whole 53, 54, 55, everything is pertaining to the same thing, just a reply to permission to appeal, not even the appeal. So it's a very small word.
My understanding, sorry to cut you off, Mr. Shaheen, is my understanding now is that these are not same documents.
It's one reply, permission to appeal, madam. That after all this work, what is being presented is one reply to permission to appeal, nothing more.
Yes, it is one reply, but it depends on who drafted it. So my concern is if council is drafting it, then it doesn't need to be reviewed by 2 other people. I would be content with 1 person reviewing, and that can be either Mr. Brooks or Ms. Jabala. But Mr. Anderson, if you can clarify between 53, 54, and 55, which item we're going to apply a deduction on.
Yes, looking at the bill of costs, it should be 55, registrar, because it's you can see from the description it's Mr. Brooks, and it's only Mr. Brooks at this stage. It's not Mr. Jabala as well. Preparing detailed email regarding draft submissions, 12 minutes, and then on the 7th, and then preparing detailed email regarding submissions, 12 minutes. So to just give you the chronology, 52 is the more substantial one. It's the solicitors considering the application for permission to appeal, and it also includes their drafting the instructions to council. Then 53 is payment to council to prepare the written submissions in response to the application. Then
sorry to stop you there again, Mr. Anderson. 52 is 2 emails that went out. 53.
That's my fault. It's 53. I'm doing 53, 54, 55. Not...
Okay, so 53. These are documents that I'm assuming that these are the documents. Could it be that they're the other way around? So we paid the fee to council, presumably from Al-Tamimi to Matthew Watson's chambers for the drafting of these submissions in opposition to permission to appeal.
Yes.
That to me, I don't see any issues with that on the basis that that's a disbursement. But again, my concern is it does not take 2 senior fee earners to review work provided by council.
Yes, exactly. And the point is that 53 doesn't include the work on reviewing the submissions, because that's
Then
all.
what does it conclude?
So that includes once we've received the application for permission to appeal, it's consideration of that before council has been instructed. So it's as you can see from the bill of costs, reviewing the permission to appeal application, considering advice to the bank, considering whether the application and new jurisdiction argument, and then Mr. Jabala perusing and considering the appeal notice as well, and Mr. Brooks drafting instructions to council. So none of the work in 53 concerns the written submissions. It's considering the permission to appeal. 54 is then the written submissions, and item 55 is Mr. Brooks spending about 40 minutes looking at the draft submissions that Mr. Watson has produced.
Then I'm going to maintain my earlier consideration, Mr. Anderson, on 20% deduction on that.
On
53. Mhm.
Okay, but then on that basis, is 55 allowed in full?
55 is allowed.
Okay. I'm grateful and sorry for the confusion on that. So then 56. This is a small one as well. It's 12-minute email regarding comments within non-routine email received from council. It's not really clear to us what the dispute is in relation to this, but we've just said it's 12 minutes. It's in relation to emails from council. There's no reason why it should not be allowed at such a small figure.
Mr. Shaheen?
The same thing, the response to the permission to appeal. Considering draft permission to appeal submissions, 36 minutes, continuing to prepare, that's the way it goes. So it's a duplication and it's highly exorbitant.
Mr. Anderson?
Well, we say it's neither duplication because it's a new email that's been received from council, but neither is exorbitant because it's only 370 dirham in the context of a $6 million US claim.
Nobody even considered the claim. No one even considered the claim. We were on jurisdiction only, and there's a permission to appeal. Every time we need not be scared by the $6 million. It's a bank took.
We are looking at 58, Mr. Anderson?
56, registrar.
Sorry?
56, registrar.
56.
No,
So one long email, 6th of June, reading and noting comments within non-routine email received from council, preparing email in response 12 minutes. So it's actually considering email received from council and then responding to it in 12 minutes. We say that's reasonable.
I'm going to allow it.
I'm grateful. 57 is then a documents item.
I don't see a figure here in the reply.
Yes. I don't think
Sorry.
one was included in the points of dispute. No, there wasn't. It's page 218. There wasn't one in the.
218.
There wasn't a figure included in the points of dispute.
I don't see a figure here either, Mr. Anderson.
No, we're not sure what figure is challenged.
Okay. Shall we just move past it then?
That my submission would be that there's no proper valid challenge to it, so it ought to be allowed.
But we don't know what the amount is, Mr. Anderson.
Oh, I'm sorry. Well, the amount is in the bill of costs, which is. I'm sorry.
I'm
I thought
looking
you were
at page
asking.
218.
Yes, that's the
And I
point.
don't see an item there either. I don't see an amount there.
No, so we weren't sure the amount that from the points of dispute that actually was being disputed, but the amount being claimed is at page 184. It's bottom of 183 to top of 184, Registrar.
$184.
Yes, so bottom of 183, top of 184, item 57. It should be 7,400 dirham.
Unless it's considering draft permission to appeal submissions.
Yes, and the only item there that challenge in the points of dispute is the 6th of June 2022, continuing to prepare the draft submissions. And what we've said in the points of reply is that this is time spent by Mr. Brooks reviewing council's draft submissions, making amendments and track changes, suggesting additional points that ought to be included, etc.
Did we not already discuss this point, Mr. Anderson?
That was, so if you look slightly above the detailed email regarding draft submissions, I think this is the first time that the draft submissions themselves are reviewed by Tamimi. And it's only, it's 2 hours, 6 minutes there, and then 54 minutes the following day. So there were emails about it before now, but this is when the solicitors review the actual document itself.
Okay. That makes sense. Mr. Shaheen? You're on mute, Mr. Shaheen.
The difference between 53 and 57, it's all pertaining to the same permission to appeal and response. Same people spending more time on it. And end of the day, it's a permission to appeal what is being opposed to. So it's highly exorbitant and there is a duplication here. It's to be completely disregarded.
So just going back from 53, I'm just trying to get the chronology in order. So 53 is reviewing and considering the appeal notice.
Yes.
And this was done by Mr. Brooks and Ms. Rita Jabala.
Yes.
54 is the disbursement to council for the drafting and the preparation of the opposition documents.
Yes.
55, 2 emails by Mr. Brooks. I'm assuming these are back and forth emails to council.
Yes, about the submissions, yes.
About the submissions. And then there's one email here in item 56. This email, do we know what it relates to?
Yes, this it's non-routine with council. Obviously it will be privilege registrar, but it will no doubt concern the submissions.
Would you be able to provide us with the date of this email?
The date of the email, yes. It's not there. It should be 6th of June 2022.
So on the 6th is Mr. Brooks drafted an email. And then on the 6th as well, he received the submissions and was reviewing them. Surely they should be. I'm assuming the email came from council.
Yes, but I think 56 is separate because it's a non-routine email. So it will be obviously in relation to the proceedings, but probably not in relation to the submissions. Because that's included in 55.
I'm going to ask for a deduction of 20% on this item.
On 57, Registrar.
On 57.
I've got a note of that. Then Item 58. This is a two email judge. One is a routine one at 185, so we ask you to allow that. The other is a longer email at 12 minutes. Reading and noting comments within non-routine email received from claimants' representatives. So, in other words, we received an email from Ms. Khoury. We had to read it, consider it, and draft an email in response, and then send that. So it's just standard inter partes correspondence, this email.
Okay, Mr. Shaheen, anything to say in response?
About emails, internal correspondence, and they said they'll produce something during the detailed assessment hearing. Nothing has been produced, so I'm disputing it.
We've described in the reply, if it helps their registrar, that the routine email is in relation to the availability of the bank's legal team in the process of sorting out the listing of the hearing before the Court of Appeal. So we say it's standard inter partes correspondence, and there's no reason not to allow it.
Okay, I'm going to allow it.
That then brings me on to 59. It's just a single email, longer one, 36 minutes, preparing long advice to the bank in relation to the court order. So this is the first email that that my instructing solicitor sends to the bank once the Court of Appeal has given its the Chief Justice hands down his decision granting permission to appeal. And that was an order made with reasons as well. So that 36 minutes in providing advice to the bank was explaining the basis of the Chief Justice's order and essentially summarising it and advising in relation to that. So that was obviously a very important email. It was when the Court of Appeal gave permission to appeal. We say that 36 minutes to send that to the bank, explain what it meant, and advise in relation to it isn't disproportionate or unreasonable.
Yes, Mr. Shaheen.
It's a speaking order, just forwarding it to the bank would understand why the judgment has come like that, okay? And then to explain it further, then nothing being produced at the detailed assessment hearing as promised. I'm disputing it, it has to be disallowed.
Mr. Brooks, can we take this down to 20 minutes, please?
Yes. Then item 60 is one non-routine email regarding the Court of Appeal's order, and then 10 routine emails liaising with counsel and counsel's clerk in relation to the decision to grant permission to appeal. And you can see in the reply, it's routine emails concerning requesting fee estimates from both leading and junior counsel and dates of availability, etc. So it's all sort of routine emails to ensure that counsel is available for the Court of Appeal hearing. And we say there's no reason why those should be disallowed, given that they are standard routine emails.
So is this the email where the defendant confirmed availability?
No, these are separate, I think. These are now emails with the defendant and the defendant's counsel, London Council, asking about counsel's availability for a Court of Appeal hearing going forward. So I think they are separate, yes.
I'll cut this in half, Mr. Anderson. 6 minutes would be more than enough.
Okay, so 6 minutes on the top one, but the routine emails are intact, Registrar, is that right?
Yes.
Yes, I'm grateful. Um, 61 is then an email about availability. Registrar has a further email about availability. It's a 12-minute, small amount claimed. The claimant, Ms. Khoury, says that it's a very short email and that 12 minutes was disproportionate to produce it. We don't accept that it is a very short email, but also in preparing it, obviously it required the solicitors on my side to rearrange their diaries as well. And obviously it was very important that correct dates were given to the registry so that there wasn't a clash of diaries going forward. So we say that 12 minutes to ensure that availability is correct and rearranging things to make sure that availability is there, plus then drafting and sending an email in relation to it is not out of all proportion to 12 minutes.
I'm going to allow it.
62 is in relation to the Court of Appeal. Point made in points of defence, repetition of the same work done. And this, I think this is the same point in relation to Mr. Brooks and Ms. Jabala, both spending time on the case in the sense that it's not duplication, it's just the senior associate and the partner having to consider the order. The cost principally claimed here relates to consideration of the Court of Appeal's granting of permission to appeal. And it's only 1 hour, 12 minutes by Mr. Brooks and 30 minutes by Mr. Jabala. And we say that those times were reasonable and proportionate in the context of a confirmation that this case was going to the highest court in the DIFC. And it was their consideration of the substance of both the Court of Appeal's order and obviously the schedule of reasons of the Chief Justice as well. So 30 minutes for the partner to look at that and consider it, and 1 hour and 12 minutes for the senior associate to do the same, we say are not unreasonable or disproportionate.
I'm going to allow 30 minutes for Mr. Brooks, Mr. Anderson, and Ms. Jabala 30 minutes as well. So she can, the time is the same for Ms. Jabala, but for Mr. Brooks, it's 30 minutes.
Grateful. 63, there's one routine email at 185, which we'll ask you to allow, and then 2 long emails. Preparing long and detailed advice to the defendant is one of them at 54 minutes, and then reading a note and comments within non-routine email received from the defendant. Routine email in response 12 minutes. As you can see from the points of reply, this email concerned the merits of instructing leading counsel to appear in the Court of Appeal, and what needed to be explained to the bank was essentially that there was no opportunity to appeal the Court of Appeal's decision. So obviously it had to think carefully about whether or not it wanted to incur the cost of instructing leading counsel in that context.
Mr. Anderson, sorry to cut you off. Would you just bear with me 1 minute? I just have something urgent has come up. If you just give me 1 minute.
Of course, Registrar.
I cut you off. Yes.
Not a problem at all, Registrar. I think I was just saying in relation to 63. Yes, but well, it was a long email just explaining whether or not the benefits of instructing leading counsel for the Court of Appeal's decision. and we say that just general advice about how to approach the appeal to the Court of Appeal. Given that it was obviously a highly important appeal, and it was going to the highest court of the DIFC, we say that it was appropriate and also reasonable for costs to be incurred in advising the bank on all its options and how it decided to run its case in the Court of Appeal. And that the routine correspondence connected with that, there's no reason to disallow that either.
Mr. Shaheen?
Which item is that? I lost the number. 63. Again, the internal correspondence, which I have no access to verify, and it was all stated that finally they'll be producing supporting evidence at the detailed assessment hearing, which I would have been able to verify. All the items they have stated is nothing produced so far. So I have to dispute it. I cannot agree with this one. And we should also bear in mind all these items starting from 53, it's all related to a permission to appeal. So it's highly exorbitant and disproportionate to the matter in hand. It's not about $6 million, it's about jurisdiction.
Mr. Anderson?
Yes, Registrar, just on the point about the provision of the supporting evidence. My instructing solicitors did send the registry a share file link which contains emails in support where supporting evidence can be produced, as said in the points of reply. The registry has been provided with that, but obviously we couldn't provide that to the claimant because it would contain privileged emails. But it is there in case the registry wants to see it. But normally the way that a detailed assessment would proceed is on the basis that the solicitors sign the statement of costs, and if the court needs to take instructions from counsel in relation to particular items, it can do so, as it has been doing during the course of this hearing. So there's no reason to suppose that where descriptions are given in the bill of costs or times are described, that they are not correct, because the bill of costs has been signed by the instructing solicitors. The only question really in relation to this item is whether you're prepared to allow the full amount of time, the full 54 minutes, for preparing that very long and detailed advice to the bank in relation to how it approaches the Court of Appeal hearing. And we say that that ought to be allowed in full.
Okay.
Just one point, Madam Chair. It
Yes.
looks like all the submissions were made to the registry, including the skeleton argument, just like that. We have not been given a copy of anything. So we have no means to verify it, whether it's correct.
Sir Shaheen, Mr. Anderson has already spoke about the fact that these are pieces of privileged correspondence, and this is normal practice, that not all emails are provided to the other side. And this is why we have a statement of truth that is signed by the solicitor when they are submitting a bill of cost. This is standard DIFC courts procedure. As a registered practitioner, I would imagine that you have awareness of these processes. I don't think this is anything new. And we cannot keep rehashing the same argument over and over again. We've already determined it. The second point that you make is that the emails, again, we discussed the emails are normal standard practice. There is nothing new there. And I can confirm that I've reviewed the document that Mr. Anderson sent. It was sent to me this morning right before the hearing. So I've seen it. Is there any other argument you wish to make? Something new to me, something that I've not heard from you today?
I'm sorry, I never said anything about emails being submitted to the registry and not copied to me earlier. This is the first time I'm making that statement. It's not repeating it again and
That
again.
is not what I said. That point was in regards to your other point about privileged correspondence. You will not be seeing those pieces of correspondence because they're privileged. If you want to see them, you can file an application to see them. The second piece of argument that I have had to rehash to you is in regards to the skeleton argument. You have not filed your own skeleton argument. You yourself have not filed a skeleton argument. I don't understand why you would want to see a skeleton argument that makes absolutely no arguments, which I have said to you that are of relevance. to anything that you have to say in response. We can keep rehashing this over and over again, but at this point in time, it's a waste of your time, Mr. Anderson's time, and my time for which you will have to pay for at the end of this hearing.
I just
Can we
mentioned,
please continue and move on? We are almost done.
I did not argue again on the skeleton argument. I just made a reference to that because the undertaking is given here. Supporting evidence can be produced at the detailed assessment hearing. So
Which
when
it was
something-
produced. It was produced to the registry. It was produced to the registry. There is no requirement that it be produced to you if it is privileged correspondence.
I don't know whether it's privileged. That's the statement given by them in the explanation. I'm relying on that. If it is privileged, they should have stated in the explanation itself, not now. I'm expecting to see that when they make a
Mr.
statement.
Shaheen, you are not doing your client any favors at this point in time. You are not doing your client any favors.
I've been doing this for a long time now. Thank you.
Mr. Anderson, for this point, item number 63, detailed advice email drafted on the 5th,
Yes,
on the merits of instructing leading counsel.
yes.
Was it the same counsel that we that appeared in the appeal? So was it Mr. Watson,
Sorry.
or was it a different counsel?
No, so up until this point, it had just been, I think, Mr. Watson acting, but the question was whether or not I think it was QC at that time before the Queen passed away. I think the question was whether a QC should be instructed as well, given that it was a Court of Appeal hearing. And ultimately, I think Mr. Montague-Smith, Casey, was instructed to do the Court of Appeal hearing. So the discussion was whether or not the bank ought to instruct a senior QC from London in order to conduct the Court of Appeal hearing. And I think ultimately the decision was taken that a QC should be instructed.
I'm going to disallow it, Mr. Anderson. I will allow the email only.
That then brings us to 64. Registrar. These are essentially standard emails between solicitors and counsel. You can see 12 minutes discussing counsel's involvement and fees. And then the second long email is reading and noting comments within non-routine email received from counsel. And then finally a routine email at 185. So it's essentially administrative points. We put in the points of reply there. It's about instructing counsel potential fees for the appeal, and then the emails in response to counsel advising which judges the appeal had been listed before, and also questions from counsel as to what directions, if any, had been given by the Court of Appeal. So we say it's all very standard correspondence between solicitors and counsel, very small amounts that we say were reasonably incurred and ought to be allowed in full.
Yes, Mr. Shaheen. Mr. Shaheen, any submissions in response?
Nothing more to add. It's exorbitant. We are disputing the cost.
This is item 64, Mr. Anderson.
Yes, Registrar, yes.
I'm going to allow it.
I'm grateful. Then the next items that are challenged are 67 and 68, and it might be worth taking these together to some extent because these are challenges to counsel's fees for the Court of Appeal hearing. 67 is leading counsel's fees, so Mr. Montague-Smith, Casey's fees. of 144,847 odd dirham, and then junior counsel's fee is half of that as well, and that's item 68. Essentially, what seems to be said is that those fees are disproportionate and exorbitant by reference to the registrar's direction on indicative hourly rates. But of course, brief fees for appearances at hearing for London Council aren't calculated by reference to hourly rates normally. But also these, of course, these fees, they don't just cover the attendance at the hearing, the sort of 5 hours in the Court of Appeal. They cover the entirety of counsel's preparation for the Court of Appeal. So that's going to include drafting the skeleton, reviewing all of the authorities, preparing oral submissions, all of that sort of thing for a full one-day Court of Appeal hearing on an issue which was complex because it gave rise to issues of jurisdiction and procedural, tricky procedural issues on service of the claim form. But also, in addition to complexity, also high value and high stakes as well, because the upshot, if the bank succeeded in the Court of Appeal, was that it would knock out a $6 million claim that had been brought against it, and that would be the end of the claim in the DIFC. It was a complicated appeal, and you will have seen from the bundle that the Court of Appeal's judgment was 21 pages long as well. So it wasn't just a sort of a short point. In fact, there were, I think it was 7 grounds of appeal that were ultimately pursued as well. So taking all of those factors together, Registrar, we say that that brief fee of just under 145,000 dirham was not grossly exorbitant or excessive. It was reasonable and proportionate, especially by reference to the potential value of the claim if it could go ahead, and also the complexity of the issues involved.
And then looking at item 68.
Yes.
Because you said that they should be dealt with together.
Yes, yes.
So this is for junior counsel assisting Mr. Montague Smith.
Yes, this was
PC up here. Okay.
Yes, this was Mr. Watson, and his
Mr.
fees
Watson.
Yes, I think his fees are calculated essentially as half of
50%. Yeah.
Yeah.
Mr. Shaheen?
Yeah.
Highly exaggerated, exorbitant. And if we look at page number 187, item number 66 in their submissions, it's just 4 hours and 48 minutes, the whole hearing. And the charges, if you see, is 144,000 for that. So if you look at it, 5 hours, little extra, how much is the charge per hour? 30,000, 35,000? Even if the debriefing time, whatever time required is included in that. So that's the way it's calculated. And it's not to scare us by every time saying $6 million claim. It's on jurisdiction, just one paragraph in the contract to decide whether the court has jurisdiction or not. And 144 and then again 72, highly exorbitant. Maybe 20% or 30% of that may be reasonable, nothing more than that. This is too high. And 66 is also again about 8,800 attending hearing, debrief with counsel and conference is already charged 8,800. 66, which I did not even dispute, but 67 and 68, no way to accept. It's too high.
Mr. Anderson, my concern is in particular with regards to instructing leading counsel when junior counsel, in my view, was more than capable of appearing before the Court of Appeal. Is there anything in specific that you think you can make in submission to that concern?
Yes, well, I suppose the starting point would be that given that it is a hearing before the most senior court in the DIFC, it's far from unusual to have leading counsel involved. That's the first point. The second point is that Mr. Watson at the time, I think he's 2012 call, so I think at the time he would have been only sort of 10 years experience, whereas Mr. Montague Smith is obviously a lot more senior and has a lot more experience in the DIFC. So in my submission, it wouldn't have been feasible to have Mr. Watson appear before the Court of Appeal because he is in relative terms, quite junior. He would only have been about 10 years post-qualification at the time. And that's quite significant in the context of a one-day hearing before the Court of Appeal.
And this was a full day hearing?
It was a full day, yes. It was a full day. As I say, 7 separate grounds of appeal. And also, the reason that permission to appeal was given by the Chief Justice was that it raised a novel issue about jurisdiction clauses, which were sort of one-way, unilateral jurisdiction clauses, in the sense that it was a jurisdiction clause that said that the bank could essentially sue where it wanted, but the parties did agree to the DIFC jurisdiction, essentially, if the bank chose. So that was something that the Chief Justice recognised in his order granting permission to appeal, was separate to the prospects of success, was another compelling reason. So obviously the Chief Justice considered that this was a point that needed to be determined by the Court of Appeal as a matter of importance for subsequent judgments as well, and subsequently developing the law in the DIFC, a sort of novel and complex point about jurisdiction. So in those circumstances, again, we say having leading counsel who'd have been involved in numerous similar types of jurisdictional dispute to this wasn't unreasonable or disproportionate, and it's not unusual at all for leading counsel to be involved in Court of Appeal hearings, but especially so like this one, where it was not a straightforward Court of Appeal hearing. It was a complex one where the ramifications of the decision were likely to be important for the DIFC's jurisprudence on its own jurisdiction and how to interpret jurisdiction clauses, etc. So given that this was a publicly important appeal, and given that the stakes were very high, it could and did result in a very significant high value claim being dismissed against the bank. We do say that it was appropriate to instruct leading counsel, so leading counsel's fees shouldn't be sort of removed entirely. If the registrar's concern is in relation to the level of fees, in my submission, it would be more appropriate to make a reduction rather than to conclude that leading counsel shouldn't have been instructed at all. That would be my submission.
And then I will just make a point, Mr. Shaheen, and then I will allow him the opportunity to respond. In that case, what was Mr. Watson's involvement if we had Mr. Montague-Smith doing the advocacy, so appearing and assisting and preparing in your submission? Is that not a duplicate?
No, Registrar. My submission would be no. It's not unusual for, it's in fact very usual for junior counsel to be involved to assist senior counsel. What Mr. Watson's role would have entailed would be producing things like doing first drafts of, for example, the skeleton, and having discussions with Mr. Montague-Smith as to how the appeal ought to be run, how the arguments ought to be constructed, how they ought to be presented to the court. And what leading counsel, I think, tend to say is that actually it's more cost effective to have junior counsel involved to produce those first drafts of those documents, because otherwise leading counsel would have to do them from scratch. And it's similar to the way in which the division between senior associates and partners works, I think, in the sense that it tends to be more cost effective to have someone on a lower hourly rate to do the sort of bulk of the written work. But then at the same time, it's Mr. Montague-Smith who is on his feet doing the advocacy, so he does still have to spend days and days reading all the relevant cases and preparing his oral submissions to be made to the Court of Appeal. So again, it would be my submission that it's not, it wasn't unreasonable to instruct both leading and junior counsel. If the registry has concerns, if the court has concerns in relation to that, it's better reflected in a deduction of the fees rather than removing those fees entirely as having been unreasonably incurred.
All right, Mr. Shaheen.
First of all, again, I repeat, highly exaggerated, exorbitant, so much of petition, and I share the same concerns what Madam raised with Learned Counsel. On top of all that, DIFC registrar's direction is the direction number 1 of 2023, the standard rates that can be applied. And if the council is not from Dubai outside, a little bit extra, something like 25% extra is understandable, but not 35,500 per hour. This is unheard of. So the standard rates can be considered, the RD1 of 2023, issued by the Honorable Registrar.
I'm not going to ask Mr. Anderson to respond to that point because he already made submissions initially on that point. I'm going to ask for a 35% reduction, Mr. Anderson, for both Mr. Montague-Smith's fees and Mr. Watson's fees, so junior counsel and leading counsel.
I'm very grateful, Registrar. I have that noted down. Hopefully not too much longer then. Those are the sort of big costs. Item 69 is a few emails. We've included 11 routine emails, so I would ask that those be allowed on the basis that they are routine, but they're just described together in this particular item. Then there's 2 long emails for 24 minutes and a telephone call. And we've clarified in the points of reply that these dealt with the construction of the hearing bundle for the Court of Appeal. You'll obviously be aware, Registrar, there are quite strict rules of how those bundles are prepared for the Court of Appeal, so it's important that the legal representatives get those right. And also there was some...
Just checking on this point, Mr. Anderson, the bundle would have been prepared by the claimants at this point. So is there an additional bundle being provided by the defendants?
I don't think so. I think this is just correspondence inter partes between how the bundle should be prepared. I don't think we're not, I don't think, claiming costs in relation to preparation. It's just inter partes correspondence about the preparation of the bundle. And then there was a routine telephone call about accessing the hearing bundle as well. All of this is inter partes correspondence. We've said that it should be in the claimant's possession as well. So
okay, no issues with that.
70 is a routine email which we ask you to allow.
That is allowed.
71 is 10 routine emails, but they're all routine emails as well, claimed on the same basis. We've just clarified in the points of reply that they are emails to leading and junior counsel and chambers in the lead up to the Court of Appeal hearing.
Do we have any more specifics on the nature of these emails?
I think I can just have a quick look at them to the extent that they're not privileged. Some of them were concerning getting council access to case lines back when the DRC was still using case lines for its bundles. Comments on sort of authorities that needed to go into the bundles as well. Supplemental notes, correspondence about statements of costs, those sorts of things. So all sort of routine in my submission emails to be sending just before the hearing.
Okay, I will allow those.
I'm grateful. Then 72 is just a single routine email which we'd ask to be allowed.
This is allowed.
Then 73 is a bit more substantial. It's essentially documents in Schedule 6 relating to the Court of Appeal hearing itself. And it's just Mr. Brooks whose time is claimed for this. I don't know, Registrar, whether you want to have a quick
Yes.
schedule. It's at page 198 of the bundle.
198.
So it's essentially document work in relation to the appeal hearing, in relation to the bundle index, the skeleton argument, emails, and the statement of costs.
Mr. Shaheen?
It's all, if you look at 69, 70, 71, 72, these are all emails in the same month, October. 11 emails and again 10 emails, one email here, one email there. And I have no access to any of these emails. So I'm unable to comment, but it looks very exaggerated and exorbitant in terms of resources. All are in October. This is what I see from the explanation, and which is stated that it to be produced during the detailed assessment hearing, and I have no access. I have not received anything.
My question was in regards to line item. Sorry, I've lost it now. 73.
Now coming to 73, see, this is regarding the skeleton argument. So I was not asked about 69 to 72. So I submit generally about that.
I understand that.
And
but my
coming
question is in regards to 73.
73, they're talking about the skeleton argument, which is just a repetition of what was already submitted before. There's nothing new in the skeleton argument as such. So the time charge, the amount charged is highly exorbitant. Maximum, I would consider 5 to 6 hours for preparing that. Nothing more than that.
Mr. Anderson, similar concerns in regards to this.
Yes.
The skeleton argument was prepared, I'm assuming, by counsel, whether it's junior or leading.
Yes.
To looking at the bill of costs. Sorry. So the bill. So the schedule 6.
Yes.
I don't know the extent of preparation that would have been required from Mr. Brooks at that point in time. There's proofreading, there's amending. I'm assuming if Mr., for example, just based on how I envisaged the process to be, it would be Mr. Watson drafting the skeleton argument in first draft. Mr. Montague-Smith would have had approval. Mm-hmm. Does it really require a third layer of review by Mr. Brooks?
I suppose the submission I make in response to that, Registrar, is that obviously council will put together the sort of the draft and the skeleton, but Mr. Brooks is then the contact point between him and the lay client as well. He obviously is he's the contact point between the bank and council, so he will obviously have knowledge of the bank's concerns and comments they may have and what they would like to see in the skeleton, that sort of thing. So his review would be necessary from that perspective to make sure that the bank's comments and concerns in relation to what is ultimately their document or a document being filed on their behalf is being filed. But at the same time, it would be, in my submission, it would be unusual for him not to have at least some involvement, given that he is the firm on record for the bank filing the document. And really, it's then a question, I suppose, of how much time should he be given to look at it. Given that it was a substantial document, I had a look at it yesterday. I can just tell you the size of it and the paragraphs. It was a 16-page skeleton, 70 paragraphs addressing 7 grounds of appeal. So a couple of hours to look at that on behalf of Mr. Brooks. I think we would say that that's probably reasonable, and he's not trying to claim any more. He's obviously reviewing it substantively, but also at the same time picking up typos and things as well. So I think in the context of this, the size of this claim, I think we would say those aren't unreasonable costs in the schedule for him to have incurred.
Just looking at Schedule 6, Mr. Anderson, we have preparation for the upcoming appeal, and then we have attending to emails received. And then we have considering and working on the appeal bundle index, which seems to be something that was also referenced later down in the schedule. Working on skeleton argument and bundle, preparing for hearing. These are very vague in my view and don't give a clear picture on what exactly Mr. Brooks was charged with doing and whether or not it would be fair to the claimant when reviewing costs on a standard basis, that we allow the level of involvement that Mr. Brooks had at this stage, specifically when two other senior members of the defendant's legal team were involved.
So
honestly, to put it, to be more coherent, my large issue is the three large chunks of time on the 10th and the 11th and the 12th. So 2 hours for working on the skeleton argument, and then continuing to prepare, including considering. So this is 2 hours and a half, and then another almost 3 hours proofreading and amending the skeleton argument. To me, that does seem a bit excessive, and I would like those specific times brought down. So a 60% reduction on those times while allowing everything else in full.
I'm great for registrar, so 60% reduction. I'm grateful then. Only 3 more, I think. Item 74 is, so it should be, it's described as 74 in the points of reply, but it's 75 in the bill of costs. It's 370 dirham. It's an email advising on the judgment, on the Court of Appeals judgment. So it's just an email to the client, having received the Court of Appeals judgment, advising on what they've said. And in my submission, 12 minutes to condense a 21-page Court of Appeal judgment into an email is
impressive.
Yes, exactly. Yes. So that's 74. Then issue is taken with the final 2 are in relation to the costs of the detailed assessment proceedings, so preparing the bill of costs, etc. 77 is the same point that the claimant makes, referring to point 47 and paragraph 10.2. We, in essence, in 77, we have claimed for inter partes correspondence relating to detailed assessment, and also correspondence with the bank seeking instructions in relation to the detailed assessment as well. And those in my submission are not unreasonable, and indeed they're necessary costs that had to be incurred in order to get this assessment up and running and filed before you today. So we say there shouldn't be any basis for disallowing those.
Mr. Shaheen? You're on mute, Mr. Shaheen.
Regarding emails and exorbitant charges repetition.
So these are four long emails, Mr. Brooks.
Sorry, Registrar, say that again.
We are on item 77.
Yes.
So we are looking at 4 long emails, 1 hour, 2 emails for them in total.
Yeah, sorry. So there's two separate claims here. One is 2 routine emails at 370.
Okay.
So I assume a fine, and then 4 long emails at 1850, which are 3 12-minute emails and 1 24-minute email. And they're all about liaising to do with the detailed assessment.
I will reduce those by 20%, Mr. Anderson.
I'm grateful, Registrar. Then finally, item 80, which is the disbursement to the cost lawyer for essentially preparing the bill of costs. What Ms. Khoury says is that there isn't a breakdown of her hourly rates, the cost lawyer's hourly rates, in light of the registrar's direction. But the cost lawyer is an external lawyer, I think actually based in England, because she was paid in pounds sterling, who charged a fixed fee for preparing the bill of costs. That's what the larger figure is, and then obviously the 1,850 is Mr. Brooks' time in reviewing the bill of costs. And the question really for the court is whether that fee is reasonable and proportionate given the number of items included. Obviously, we've got sort of 20 to 30 pages worth of costs here. Obviously, the cost lawyer is a specialist in preparing these, so probably actually save time and cost by having her do it rather than Mr. Brooks having to do it as well. So we say that was a reasonable outsourcing to do, and it's probably saved some costs actually in the end.
Sir Shaheen?
Highly exaggerated, only for preparation of bill of costs, so much time, and the breakdown is not given. I'm unable to comment. And here at least they have stated that they're not entitled to claim any cost regarding the JJC application, whereas I pointed out earlier, in some areas they have done that as well. So this is to be reduced to the bare minimum.
Sorry, could you repeat that on the JJC point?
Explanation part, they have given that this was not a routine bill of cost to prepare to ensure costs that were not applicable under the various cost orders were not included. For example, the work in respect of considering the claimant's JJC application. So there is an admission here that they're not entitled to claim it in this column. But whereas in other places, they were putting the time spent on the JJC application also. And the other court.
I don't think that's correct. My understanding is that that is not correct. It was reviewing the impact of the claimant's JJC application on the DIFC court proceedings, and to my recollection, we cut down those costs considerably. And Ms. Joanne Chase is a cost lawyer with over 17 years of experience. Can we round those down, please, Mr. Anderson, to 15,000 dirhams?
Yes.
While allowing Mr. Brooks costs.
Yes, I'm grateful, Registrar. Well, that completes the individual items in the points of dispute. There are only two other points I wanted to go through very quickly, which were interest and then the costs of today's hearing as well. On interest, you would have seen from my skeleton that we are entitled to interest on our costs from the date of judgment under Article 39 of Court Law number 10 of 2004, and that under Practice Direction 4 of 2017, it's a rate at 9% per year or any other such rates the court may prescribe. Now, we obviously do recognise that we did not bring these detailed assessment proceedings within the 3 months that the rules stipulate, and the rules do say that the court is able to amend the interest that it decides to award, if any, if proceedings aren't brought in that time period. So in my submission, probably the fairest thing to do is for the court to order that interest should run from the date of the two Glennie orders, which were the first two cost orders, and then the Court of Appeals order to the 28th of February 2013, which was 3 months from the Court of Appeals order. So that
you do mean 2023, Mr. Anderson, not 2013.
Of course I do. Yes, 2023. Sorry, it's quite early over here in the UK.
Yes.
It's 28th of February 2023 as the first bit, because that would be the 3-month deadline for bringing the proceedings. But then add on to that the days that it took between actually filing the detailed assessment and then being able to come to court today, which was about 110 days. So I've tried to work that out before. What that would end up looking like is an order that interest is payable until the 18th of June 2023, or alternatively, in the order, it could be sort of 90 days plus 110 days, so like 200 days worth of interest or something. But in other words, the point I'm trying to make, which I'm probably not making very well, is that we're happy not to have interest all the way from the Court of Appeals order to today, and probably the fairest way to do it is to take the 3 months that was the deadline for filing the detailed assessment, plus the time between actually filing it and getting to court today, which in my submission we would be entitled to anyway on interest, because that's the time period for bringing it before the court. That was my suggestion. I thought that was probably a fair way of dealing with the interest in light of the fact that the detailed assessment wasn't initiated in time.
Is there any reason for the fact that it wasn't brought in time, Mr. Anderson?
I can take some instructions on that. I don't, but I don't have any off the top of my head. I'll take some instructions while you're considering it, if I can.
Right, Mr. Shaheen.
There's been a delay, and the delay, the consequences are stated there. One is the court may disallow or reduce the cost to be paid and interest not to be allowed. This is my submission.
Sorry, could you repeat that?
There is a delay in bringing the cost proceedings.
Mm-hmm.
So when the delay happened, there are certain sanctions prescribed under the law.
Yes.
The 4011, 4013, and then 38.60 of the DIFC court rules.
Mm-hmm.
So either it can be completely disallowed by the court. What it's saying is that if the receiver fails to initiate the proceedings within the decided time, the court will disallow all or part of the cost payable to the receiver by the payer. Second thing, if no such application is made by the payer and the receiver commences proceedings after the 3 months expiry, the court may disallow all or part of the interest which is otherwise payable to the receiver. The court may also impose other sanctions. So the judgment was on 28/11/2022, and this is on 24/1/2024. So there is a huge lot of delay here. So I'm appealing to the Honorable Court, Honorable Registrar, to disallow the claim on cost, or if not, at least reduce it and not allow interest.
You do mean disallow the claim on interest?
My plea is to disallow the cost itself, because that's also stated there. The payer may, by a petition, seek for the commencement of proceedings within such time. The court decide. If the receiver fails to initiate the
cost for assessment proceedings, you mean?
The court will disallow all or part of the cost payable to the receiver by the payer. The court has the power to disallow the whole or part of the cost. So my request would be to disallow whole of the cost. If that is impossible, the court is not inclined to do it, at least major part of it, and interest not to be allowed.
Mr. Anderson?
I'm not entirely sure to which rule you're being referred, Registrar. I mean, Rule 40.12 says that if there's an application under 40.11, which is where the paying party applies for an order requiring the receiving party to actually start the proceedings. If you have one of those applications, then if the receiving party doesn't start the detailed assessment proceedings in time, all or part of the costs would be that they might be entitled to will be disallowed. So you can disallow costs in that situation, but that's not the situation here, because there never was an application under 40.10. So in my submission, the only jurisdiction you have is to disallow part of the interest under 40.13, which says if the paying party has not made an application under 40.11, which is the case here, and the receiving party commences proceedings later than the period specified, which is the case here, the court may disallow all or part of the interest otherwise payable to the receiving party under Article 39 of the court law, but must not impose any other sanction except in accordance with Rule 38.60. So that rule is clear. The only jurisdiction you have in terms of penalising us for not bringing the proceedings in time is to disallow all or part of the interest.
40.12, 4012, that's what I referred to.
I'm great.
The court is authorized to disallow the whole or part of the claim.
But that's, as I say, Registrar, that's where there's an application under 40.10, basically where the paying party says, look, you've got to get on with it. You need to file your application for detailed assessment, and then the receiving party still fails to do that. That's the only situation where the court's able to disallow costs rather than interest.
Yes. Do you have a response from your instructing solicitors, Mr. Anderson, on the reason for the delay? My
Yes,
initial inclination was to disallow all of interest, so it needs to be a good reason.
My instructions are that it was time to advise the bank on what to do and take instructions on what to do. But in my submission, we're disallowing the entirety of interest would, in my submission, be disproportionate because we're very content with a sort of much more limited period. We're not trying to seek interest from the date of the judgment to today. My suggestion was basically to do an equivalent of the interest we would have got if we would have started in time. But even if Registrar, you're not persuaded by that, even the sort of 3 months worth of interest in my submission would be fair, because there hasn't really been any prejudice as a result of the delay if we're not claiming interest for the whole period.
I will allow 3 months of interest, Mr. Anderson.
I'm grateful.
There was a second point, I think, your final point.
Yes, exactly. Cost of today. So you'll no doubt be aware, Registrar, that under RDC 40.44, we're entitled to our costs of the hearing of detailed assessment, and our application is for them to be immediately assessed today. Our statement of costs, which we filed in time, is at page 475 of the bundle. And at the risk of asking you to do even more cost assessment, we do ask for these to be immediately assessed today. Just what I would say on this, obviously, it will be,
Sorry, Mr. Anderson, the bundle reference is at 75.
It should be 475, Registrar.
475.
475.
Okay. And these include the cost for your appearance today, Mr. Anderson.
Yes, they do. Those are set out at the bottom of page 476 at 18, just under 18,500 dirham. Which in my submission is good value. And then there's court fees, etc. But just on this, obviously it will be for Mr. Shaheen to take issue with the points, but I did want to say a word about the basis of assessment. And we do say that Ms. Khoury's conduct in relation to this hearing does take this case outside the norm, that you should assess these costs on the indemnity basis. And we say that for 2 reasons. The first is that we had this, what I would describe as a spurious application for a stay less than 24 hours before the hearing. And we obviously had to consider that, and I've had to prepare submissions in response to that. And my client has had to incur costs in relation to that, which obviously are not reflected in this statement of cost because this was filed before that application. And we say that it was obviously wrong, and it was obviously an abusive process because it was brought so late in the day. We rely on that. And in fact, yeah, that's the principal point. We say that conduct does take this case outside the norm. But otherwise, you'll see that the total cost claimed to just under 130,000 dirham, which is around 2% of the total value of the claim. I can deal with any issues that Mr. Shaheen takes with individual items, but in my submission, that's not a disproportionate or unreasonable amount of cost to incur in relation to this hearing.
Before I ask Mr. Shaheen to respond, there is an individual item in your brief description set out for local associate fees.
Yes, let me take some instructions on that because I don't actually know what that is in respect of. Let me take some instructions on that, Registrar.
Okay. And the second item is the cost draftsman fees. Are these the fees that were initially claimed in part of in the initial cost or in the detailed cost assessment for Miss Joanne? I forget her last name. Joanne Chase, I believe.
No, I think those must be separate, but I will clarify why they are separate and what they have been incurred in relation to.
Mr. Shaheen, would you like to respond?
What the general comments which I made regarding each item under the bill of costs. And now this has been considerably reduced also on many items. It has been reduced. Plus, this detailed assessment itself is based on the cost submission, which I said it delayed. And there is a provision, article 40.12, where I'm requesting the Honorable Registrar to disallow the costs and disallow the interest and other aspects of it because of the delay.
Mr. Shaheen, 40.12 relates to 40.11. So we've already touched upon this point. So I've already made the decision that I won't be disallowing costs on the basis that that would not be proper. I don't have that authority under the rules. I did disallow part of the interest as a sanction to the defendant for not bringing their cost assessment proceedings in a timely fashion, despite the fact that there was no prejudice or no real prejudice to your client. Is there anything in specific you would like to say with regards to the statement of costs that we are referring to right now? And this is for the assessment proceedings today. So Mr. Anderson has made submissions to you the effect that I should assess these costs on the indemnity basis, not the standard basis. And this is based on the fact that there was a surprise application brought and the fact that the cost assessment has taken a considerable amount of time. Is there anything in specific you would like to say on those points, as well as any other points in specific to the statement of costs?
All judgments are clearly stated on standard basis. There's nothing indemnity basis here. Even the detailed cost assessment should follow the judgments which is issued on the basis of which the detailed cost assessment is placed before the order. So it cannot be on indemnity basis. That's why I thought it doesn't even require a response. So, the stay application, it's my right under the law. It's up to Honorable Registrar to allow or disallow it. Even without a stay, my understanding of the article is that it has to be stayed. But I submitted an application, it has been rejected. So let me see.
Mr. Anderson, do you have a response on those specific points?
I do in relation to the cost draftsman. So that is for drafting the reply to the points of defence, which obviously weren't included in the bill because they were produced afterwards. We are not entirely sure on the local associate fees. So actually in those circumstances, if I can't explain to you what they are, I don't think I can properly claim them. Apparently it's been misdescribed. It ought to be something else, but in relation to the cost draftsman, certainly that is producing the points of reply, which obviously we've just been through, are about 35-40 pages as well. So we are trying to check very urgently on the local associate fees, which I'm told is a misdescription. But while I'm checking that, do you have any concerns in relation to any of the other items?
My only concern is that the costs for preparing the reply are very similar in amount to the cost of preparing the initial bill. And where I've taken those down to 15,000, I shouldn't be allowing a greater amount here. If we're referring to the same.
Yes, I can see that, Registrar. Should we can reduce that to?
I'm going to give half this figure. So from 17,000, I will give half of that amount.
Well, the only point I would make in relation to the reply, Registrar, I suppose, is that obviously that was slightly more complicated because it did involve having to go through item by item all of the points raised in the points of defence, plus the additional high-level comments that were included in the points of defence as well. So it was quite a time-consuming exercise to produce it, because it was sort of 40 pages that had to go through all of these individual criticisms that were levelled against us. So that's the only point I would make in relation to that.
I understand. I think I would recommend a 10,000 dirham figure in that situation. So that's slightly over half. And your fees, I have no issue with, Mr. Anderson.
I'm great.
The court fees these are the fees for the commencement, I'm assuming.
Yes, that's right.
Those should be. There's a odd legal stamping fee of 100 dirham.
Mm.
I'm not quite too sure what that means.
Nor am I actually. Just while I'm taking instructions, would it be worth, in the interest of, oh, it's for Clarion, I'm told. Would it be worth give you a ruling on the indemnity versus standard basis point while I take?
No, I will be operating on the standard basis,
Okay.
Mr. Anderson.
In which case, are there any concerns, Registrar, that you have in relation to the hours and the costs?
The hours I have no specific concern with Mr. Brooks' hours. I just would like to clarify the 7-hour work on documents done, because there's 2 different rates. This is for Malavika Vijayan. Apologies if I've just butchered the name. And then, yes.
So sorry, Richard. I think I can check this, but I think she was promoted from
Trainee
to associate actually.
Somewhere throughout these. Okay. And these 7 hours, well, we have Mr. Brooks doing 9 hours work, and then Miss Malavika doing almost 7 hours, roughly 8 hours. Can we please bring down Miss Malavika's costs by 40%? For her hours, 40%.
For her work done on documents. Or is that for all of her work, Registrar?
Just the work on documents.
Okay.
The others didn't seem excessive to me. There was another general expense claim here, other expenses total. So we have roughly 79,000 dirhams in expenses claimed in the section right under attendances at hearing. And then there's others, and then there's other expenses. If I could just be given an idea on what those would relate to.
Yes, so the expenses disbursements are all of the matters that are described in brief description other than VAT. So the others just applies to VAT, and you'll see that the figure 240390 is the same, 240390. And the other expenses total is basically all of the disbursements and expenses plus that VAT combined, which that makes the 81,239.
Okay, that makes sense. Yes. All right. Once you have a response on the local associate fees, Mr. Anderson, you said that it was misidentified.
Yes, no, that's I've just received instructions on that. That's an accidental duplication of the cost draftsman fees. Mr. Brooks has asked me to apologise on his behalf for that. So the local associate fees should be taken out in their entirety.
Okay. So then my deductions would be taking out the local associate fees in the amount of 18,725, and
Yes.
then reducing the cost draftsman fees to 10,000 dirham,
Yes.
and reducing Ms. Malavika's fees hours on work done on documents by 40%.
Yes, I have all those.
And that will be, I will leave the arithmetics to you,
Yes.
Mr. Anderson, and we can have a draft order submitted reflecting the total sum of assessed costs and the summary assessment.
Yes, and can we include an order that those be payable within 14 days in the usual way?
Mr. Shaheen, 14 days reasonable for your client?
Instruction.
We need an answer, Mr. Shaheen. Can I ask that you provide us with an answer? Today is the 15th. Can I ask that you give us an answer by the 19th as to whether your client would be able to make payment by the 20th, whether your client would be able to make payment by the 3rd of June? If not, please provide an alternative date, and I will make my decision from there.
I'll try to contact them.
Okay. All right. Thank you very much, gentlemen. And we will wait to hear from you, Mr. Anderson, or from your instructing solicitors on the draft order.
I'm grateful, Registrar, and thank you for taking the time with this. I know it's taken a while, so we're grateful. Thank you.
Thank you very much. Yes, Mr. Shaheen.
Just before we conclude, I'm obliged to make the statement. All what I have done today, whatever I have stated today, are all without prejudice to my standard.
Understandable.
Thank you.
Understandable. Thank you very much.